And one thing about this class, there's so much. One of the comments I had a person down in Kansas City was that it's like getting a drink from a fire hydrant. There's so much information we'll cover in the next 5 days. It's going to blow your mind. You'll walk out of here like a limp bush rag. Don't think you're dumber than rock. You're not. It just takes a long time to settle in. There's so much volume of information. And the reason I started doing this, and we're not recording this part, this is all just talk before we start, is that over the years, Larry Beecraft is a good friend of mine. He's one of the most prominent lawyers in the country as far as taxes. And we were discussing why all these people go to jail, all these patriots, and the reasons why. And their arguments are just so crazy. Some of them are just off the wall. The guy will walk into court and say, I'm a free white Christian virgin male, and you're supposed to be free. And they go to jail. And so I decided that I was going to stop and retire and dedicate my life to educating people in a proper way to produce yourself in court and how to win rather than lose. And that's what this course is predicated upon. It's being able to understand the law you're working with and how to use legitimate legal methods. The rules of court and civil procedure, 28 U.S.C., is the rule you die by. If you don't know those rules, you're not going to make it because they do know the rules. And your job is to learn the rules better than they do. So when you go to court, you teach them a few good lessons because they're not prepared for that. I've been training over the past 8 and 9 years about 1,000 people. And out of 1,000, probably 200 have litigated cases themselves. Out of that, probably 15 have become really good litigators and teach other people how to do it. And about 4 have become superstars, better than most lawyers I know. That's pretty good odds. I don't think Harvard has that kind of a record because the people that I talk to are motivated. You're feeling some pain here or you wouldn't be here. You realize that there's a system around us does not have our best interest in heart. And you're here to do something about it. Otherwise, you wouldn't be here. And that's what this class is for, to give you the tools you need to be able to go out. Now, there's other courses you have to take beyond this. I have a litigation class. It's a whole week. It's a litigation classes workshop where you walk in there, you're exposed to rules of civil procedure, how they're used. We actually target like a laser beam one specific, which is banks. I love suing banks. I love it. They've been screwing us for years, and I teach you how to screw them. Your mortgage, how to get a free house.
When's that taught next?
Well, we have scheduled a class we're going to have, and I'll be doing once a quarter. I'm retiring now, and I think maybe I might not retire, and maybe I'll do once a quarter. I can't take the travel any longer, and probably in Las Vegas. It'll be Las Vegas because everybody likes to go there. Cheap rooms, cheap airfare to get there, and we'll have the class there. Now, all these classes I don't teach myself. Some of them I do. I have one girl who is my superstar from Hawaii, who will probably teach the litigation class. And she is very good. So we'll schedule these different classes, habeas corpus, expatriation, all these different classes we have. We'll schedule them and notify everybody when they're going to be. If you like to go to them, sign up for them, and we'll have it. But this one class won't give you all you need, the tools. It'll give you the knowledge to understand where you're at, but you have to go a little bit farther. Now, I went to law school for 4 years instead of 3 because I specialized. But rather than go to law school and spend your time in law school learning their law, which is not the law you want to use, but you have to understand their law to understand how you use your law, which is common law. And this will give you some idea how that's done this week. But the other classes, if you're interested in continuing your legal education, I suggest that people start looking on the internet. There's law schools on the internet now that takes 4 years instead of 3. It costs you $4,500 a year, I think, instead of $35,000 I paid a year. And you do it at home. You don't ever have to go to school. And it's just as valid as anybody else's. When you're in law school, you study about 14 basic topics of law in law school, whether Harvard or Slippery Rock, Arkansas. It makes no difference. And it's the mastery of the material itself is based upon your motivation. Because you're a Harvard graduate doesn't mean anything. That means you have some pretty top flight professors, but the ones that are Slippery Rock, Arkansas are probably just as good. They teach the same law. So internet law school, there's no black cloud attached to it because you want to join the bar, finish your law school, you could take the bar. If you want to be a bar member. But we'll explain to you why that may not be a good idea. Okay, I guess we start. Welcome to the Law Club. This quotation I took out of West Virginia Board of Education versus Barnett. Judge Learned Hand gave this in 1943. Quote, "We can have intellectual individualism and the rich cultural diversities that we owe to exceptional minds only at the price of occasional eccentricity and abnormal attitudes. When they're so harmless, or to others or to the state, the price is not too great. But our freedom to differ is not limited to those things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein." Okay, this warning was sounded by William Pitt before the British House of Commons. In his message, he addressed the need for privacy, protection of life, liberty, property, and the pursuit of happiness. Quote, "The poorest man may, in his cottage, bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England may not enter. All his forces dare not cross the threshold of the ruined tenement." End quote. No longer is this a free country established by our forefathers. Under common law, we had immense personal freedom so long as it did not infringe upon the rights of others. Today, we seldom know any of our rights. The book of Hosea writes, "My people perish for lack of knowledge." In 1797, 96% of all Americans had law books, Blackstone's Commentaries, and Geneva Bible in their homes. They knew their rights and were belligerent litigants. Today, very few of us have such an awareness of nor recognize the differences in the courts of law and how each are applied and used against us, let alone what our rights are. Instead, we place our faith in the hands of lawyers and rely upon the light and knowledge they possess to protect our liberty. We are encouraged to remain incompetent by seeking professional, financial, and legal counsel. We don't realize that an attorney is an officer of the court and that his first or her first obligation is to the court, not the client. As we begin to recognize our vulnerability, it's vital to protect ourselves and our families from special interest groups that would deprive us of knowledge, right to property, inalienable rights, and privacy. Today we continue to find ourselves more heavily regulated by federal and state agencies to whom we voluntarily place ourselves subject to instead of claiming to be of the posterity of those known as the sovereign class of we the people. These agencies continue to place legislative influence over our businesses, education, commerce, industry, transportation, communication, legal, medical, health, religion, and so forth. We have given up our control of our lawful rights for that of federal legal privileges, called civil rights. By subjecting us to attorneys in the courts, tribunals, virtually a sovereign government exercising martial law rule now regulates every aspect of our lives. Moreover, once again, history repeats itself. Have you been reduced to the role of a subject serving the interests of oligarchy? Are you a citizen of the United States? If you are, you have my profound sympathy. We are to blame. Ignorance of our rights is worse than not having any rights at all. There is a price for freedom and a cost for restoring it. Special interest groups exercising martial rule control over us are hungry and broke and not likely to serve the best interest of the people as they struggle to survive and promote their tyranny. Finally, after years of research, I developed methods enough to get away from the problem and get on with my life with some degree of peace and security. This week-long course is designed to aid you in that same quest, and I hope that my years of trial and error will eliminate the necessity for you to travel that same bumpy road. For example, some of you may feel that the best course to follow is to keep the ostrich profile and don't attract any attention to yourself. You might want to consider this comment from one of our federal appellate courts. Quote, "The cooperative taxpayer fares much worse than the individual who relies upon his constitutional rights." It probably never occurred to you that you have an absolute right to cut down on what you pay to big government. The fact is, highest court in the land has told us the legal right of the taxpayer to altogether avoid taxes by any means which the law permits cannot be doubted. This is what one of our illustrious assistant attorney generals had to say about voluntary compliance with the tax laws. We encourage voluntary compliance by scaring the hell out of you. That was Roger Molson. He is now the Solicitor General for the United States. Do not confuse love of country and obedience to law with trust in and submission to government. That's the yin and the yang. We will examine over the next few days some of the practices of various alleged agencies of government, and we'll ask that you exercise some independent judgment as the basis for any actions you take in the future. Do you think that your government might have misled you? Do you have a feeling of impending doom deep in the base of your neck? Is something out there is just not quite right? Well, you're not alone in those feelings. There's a sea change revolt in this country that has the federal government terrified. I'm going to attempt in the following days to instruct you about your rights and expose you to information that you're not likely to have run into in your ordinary daily activities. I am certain that you will not ever hear any of this information by listening to the media, as they are totally controlled by the pestilential, monstrous body we refer to as the establishment. The information you are about to receive should have been given to you in high school. I hope that in your free time you might read my book, High Priest of Treason. That book was written as a primer for the uninformed citizen in this country. Let's face it, we were all uninformed. That's the national educational system designed. Their philosophy is simple, classic mushroom theory. Keep them in the dark and feed them plenty of Kalmanar. Your rights do not have any real meaning unless there are corresponding duties. Rights and duties can only exist in a natural person. For the person to have any benefit from a right, other people who might be in a position to infringe upon their rights must be under a duty not to do so. What defines the rights and duties of people is a rule of law. This does not necessarily mean that the law is written down. In fact, when fundamental rights are mentioned, they are attributed to God's higher authority. They are deemed to be inherent, inalienable, and natural, and are so basic to the human condition that everyone ought to understand them without any writing. The Declaration of Independence has ascribed such rights to the Creator. Similarly, there are restrictions on conduct which are so manifestly necessary in a civilized society it is needless to record them. Such restrictions are simply the duties which attach to those fundamental rights of living. Your right to life imputes a duty not to kill. Your right to property imputes a duty not to steal. However, not all rights are fundamental and not all duties are really necessary. To separate these categories of rights and duties, you must select a means of classification. For this presentation, the classification is threefold. 1. Natural law. Do what is right. We are all born with an abundance of this knowledge. Number 2. Man's law. Do what you agree to do. Do not trespass on me or my property. Number 3. Vulgar law. Do what I say. This incorporates nearly all statutory law. That part of the natural law which has been adopted into the practical laws of society has been merged with man's law. Those parts which deal with moral issues do not belong in the law unless they also involve real and immediate physical danger. Such laws interfere with your freedom of choice, sometimes called free agency. Usually, as you are well aware, when men try to enforce moral laws by so-called social engineering, they're resorting to the vulgar law. Statute law, as is practiced in our current courts of law, unlike the common law, compels performance and is in fact vulgar law. The entire field of social welfare legislation belongs to this class, along with a myriad of special interest laws which plague every aspect of our lives. Government's elite purport to protect us in our rights and compel us in our duties. If we were capable of abiding by the highest principle, that of brotherhood, government would be unnecessary. However, we are not so universally noble. Thus, we have to submit to the authority of government. There are two basic types of government. One is a government which is absolute power. The other is a government which is limited by law. Governments may be led by a single person, a monarchy or dictatorship, or a select group, an oligarchy, or by all of the people, a democracy. Democracy usually operates by majority rule. What is significant is that if the law does not limit democracy, then it becomes mob rule. It is mob rule because the same individuals are not always the constituents of the majority, as to each matter upon which the people must have a rule. By contrast, if a law, as a constitutional monarchy, limits a monarch, you may have an orderly society even though it has the appearance of aristocracy. In either case, order and freedom will only exist when leaders have rules of law by which their positions are regulated. The highest form of rule we have developed is called a republic. That form employs representatives who are elected by the majority to administer the power of government in accordance with specified restrictions. The point is that majority does not rule, it only elects. The French Revolution espoused the ideas of equality, liberty, and fraternity. It tried to operate as a democracy, calling itself a republic. However, there were no specified restrictions, and under the direction of influential but tyrannical leaders, it degenerated into a bloodbath. In our own country, the Declaration of Independence should have freed the slaves. It's actually applied and is blessed by the Constitution. That declaration failed to do so. Lincoln thought that the Emancipation Proclamation would do the job. Apparently, it did not. Even the Civil War left the blacks as slaves in the South. It was thought that Amendment 13 finally made them free. That by Amendment 14 and 15, our black brethren finally received their sovereignty along with the rest of us. This is a lie. The actual effect of those amendments was to bring the entire country into a kind of bondage, a form of voluntary servitude, recognized as villeinage in merry old England. It made us all equal, all right, equally devoid of freedom. My hope is that this course will show you how this bondage was brought about, how it is maintained, and what you can do about it. Later I will summarize concepts of law and government which will give you enough understanding of both to enable you to use the information to regain some of your liberty. I know just a fraction of what the truth really is. However, I have a personal quest to uncover as much of the lies and subterfuge as is possible, then to reveal that knowledge to the American people. To give you the benefit of independent judgment on their credibility, I will identify who said what, so you can check it out. My own opinions are clearly stated. You can take them for whatever you may think they're worth. The people upon whom I rely are men like the authors of the Constitution and their contemporaries, various modern public figures, justices of the United States Supreme Court, justices from other courts around the country, and a lot of people who have tried some things which have worked and some things that did not work. I will quote judicial opinions and decision a lot, and try hard not to quote out of context. Just to be sure, I will refer you to the whole case involved so you can check out my interpretations. Chapter 1, Shelter of Assets. It's time to get your priorities straight. There are 3 phases to controlling the system. The first phase is your estate protection work. You are placing the things which creditors might seize beyond their reach. However, be aware that this effort may be useless if you are already in debt. Transfers without full consideration can be set aside. If you have creditors out there, including the Internal Revenue Service, you must first deal with your creditors by settlement or bankruptcy. Of course, if you sell for full consideration, no one has a right to complain unless they can somehow show that the purpose of the sale was to hinder and delay creditors. In addition, if the proceeds of sale can lawfully find their way beyond the jurisdiction of the courts, there's not much anyone can do about it. Second phase is to utilize all the defenses allowed by law to defeat the claims of the IRS. As you will see, most of their enforcement efforts are fought with defects and can be defeated by determined resistance, both before a lawsuit and through the courts. Never hesitate to initiate action against the IRS when they are in the wrong, which is most of the time. Phase 2 enables you to deal effectively with the efforts of the IRS to entice you back into their clutches. It also will nullify most of their efforts to collect any tax. To reach this enviable position, you must know exactly how to respond to their letters and calls, and you must utilize the procedures which are legally available for your protection. These procedures are set forth in the Uniform Commercial Code, under the Paperwork Reduction Act, and the Freedom of Information Act, under the Privacy Act, and by reason of the laws relating to delegated authority. Further information on these IRS pressure points will be explained in detail. Finally, if you're not satisfied with the IRS stinger has been sufficiently pulled by your state protection measures, or if you desire as a matter of principle to draw the line against the government abuse, you may do your reclassification work. This will place you beyond the reach of the taxation system, which applies to subject citizens unless you get back into it again by subsequent consent, waiver, or other form of voluntary action. What you are doing is perfectly legal. You are simply making a public record of your true status, which renders you a non-taxpayer, or at least a payer of very limited taxes. The vital importance of this is that if you are charged with a revenue law offense, you have this reclassification record to establish that your legal basis for refusing to file tax returns. Even if the court rejected your reclassification, it would be hard put to convict you of a willful failure to file. Your belief and your lack of liability under the law is not a matter of record. How to become comfortably impoverished. Restructuring your asset attitude. Most of you have developed an attitude about property which tends to disable you when it comes to dealing with your creditors. This is the attitude which says that your success in life is measured by how much you have acquired. He who dies with the most toys wins. The falsity of this concept is readily apparent when you examine the affairs of those whom we call the super rich. Upon close examination, you will find that such people have access to every conceivable luxury. They never seem to owe a tax or be in debt. Why is this? Simply, it's because they don't own anything of significant value. Some trust, corporation, foundation, or the like owns everything they use. Such people have learned that the enjoyment of wealth, undisturbed by the envious, requires a separation of the user from the ownership of the property. When properly done, the user has the full benefit of unlimited assets, but he is legally unable to control any of them. The property is thereby beyond the reach of creditors, public or private. Of course, you might worry about being taken care of when you have no control. However, if you've handled your paperwork properly in the first place, control would no longer matter. Paperwork does the job. Paperwork commands the managers to do certain things, most of which will inure to your benefit, what does not inure to the benefit of those you care about. There are numerous methods to arrive at the enviable position of being completely insulated against creditors. I simply mentioned a few of them, sufficient to start you on your own way. What you select will depend upon what you need and desire. The point is that estate protection is undertaken not to defeat your creditors. Indeed, this cannot be done lawfully. If you physically remove assets from the jurisdiction, you may actually be committing some crime. However, if you clean up your affairs first, then you can cause the implementation of a program which gives you the benefit of full usage of your property, none of which is available to your creditors, public or private. This use can even pass to your family members, with the same insulation against their creditors. After all, if you have done your work properly, you have not misled any creditors, not even the IRS. This is neither tax avoidance nor tax evasion. Those terms simply do not have application to what you have done if done properly and timely. Structuring relationship to property. Clearing the way. Many of you will receive this information contained in this presentation at the time when you are significantly in debt or perhaps already under pressure from the IRS. The existence of these demands, present and impending, require special legal consideration in rearranging your financial affairs. A person in debt is not allowed to simply resituate his assets and then thumb his note as his creditors. If the transfer is not made for fair value, or if it is made simply to hinder or delay creditors, the transfer will be set aside as a fraudulent or constructive conveyance. It will be the same as if no transfer were made in the first place. If the creditor is the IRS, they will not even bother to seek a court evaluation of such a conveyance. The IRS will simply declare the transferee to be your nominee or alter ego. With this label ascribed, seizure will be made, and your transferee will be required to go to court in an effort to prove the validity of the transfer to recover the asset. Of course, if your transfer is to an entity in a foreign land with no branch in the USA, subject to local jurisdiction, neither court action nor seizure will be effective against that transferee, unless the foreign jurisdiction is a party to a treaty of some kind allowing American creditors or our government to be assisted in debt collection, usually taxes, in that foreign place. Be aware, however, that such a transfer might be punishable as a crime. To determine whether or not you are open to claims of fraudulent conveyance or alter ego, you must understand the three different classes of creditors: present, future, and potential. A present creditor is one to whom you now owe money or some legal duty. As to him, any conveyance for less than fair value, whether or not you intended to hinder or delay collection, will be set aside on demand. The IRS claims this position as to any tax which has been assessed against you. A future creditor is one with whom you are involved financially or doing business wherein a future liability is presently determinable. This may arise where you built a home subject to some guarantee and the building is defective. Common sense should be sufficient to tell you whether or not any relationship which you have with another involves a determinable future financial or other obligation. Such a creditor can reach the transferred assets if he can be shown that they were transferred for less than fair value or with intent to hinder or delay collection or enforcement. The IRS would be in a position of a future creditor as to any income which you have become entitled to receive, for which you have a duty to make a return at any time. In both the foregoing situations, the IRS will assert that your transfer was to a nominee and will proceed with a seizure. If the transferee was a person who conspired with you to conceal assets, that person may become personally liable for your taxes to the extent of the value of assets so concealed. By contrast, if the conveyance of property was to an entity formed with a substantial business purpose and all the procedural requirements for the creation of new business entity were satisfied, the integrity of the business will be respected. A potential creditor presents no problems to anyone. You're not required to structure your life to protect anyone who might be in some future day extend you credit or have a claim against you. If it were otherwise, the laws pertaining to gifts would be meaningless. The IRS is a potential creditor as to taxes on income which you have not yet become entitled to receive. Neither the IRS nor any other potential creditor will ever have a legal claim on assets which you sell, transfer, give away, or dispose of, no matter to whom or by what means you may do so. Also, always look up the local statute of limitations concerning conveyances, because even a fraudulent conveyance may be immune from attack if done long enough ago. If you are exposed to the problem of present or future creditor claims, you must be sure that your conveyances are completely valid. If you have sufficient assets to deal with all claims, you are solvent. If the transfers whom you contemplate will not make you insolvent, you will probably have no problem. However, if transfers might render you insolvent, you cannot make them without regard for the consequences. This means that you must first receive fair value and be acting without intent to hinder or delay collection. The matter of fair value seems quite simple. Just sell or trade the asset for money or equivalent value. And unfortunately, many things which are actually of equal value are not so treated when the creditor comes calling. A transfer to a trust in exchange for certificates of interest or to a corporation for its shares is clearly fair value transactions. In fact, even if the certificates or shares are made assignable to a third person, there is a fair consideration. The problem is, in the first instance, it might be deemed to be a transfer to hinder or delay creditors. In the second, the assignment of the consideration is a gift without fair value to you, and may be treated the same as if no assignment were made. Unless the transferee is outside the reach of local law, he may be required to return the asset to you, meaning to your creditors. By this analysis, we have reduced the solution to the problem to two obvious steps. Get money for the transfer. Unless it is to defeat a tax claim, move the money to a jurisdiction where it cannot be seized. If the IRS is involved, you cannot make such a transfer unless it is to purchase some asset for value from a foreign source. However, there seems to be no requirement that the asset be returned to a jurisdiction within reach of the IRS. Just be sure the transaction was not intended solely to or as a device to defeat collection. Special warning, you must be heeded. If the IRS has substantial claims against you, you may find yourself unable to secure a passport to do those things offshore, things that you wish to do. Unless you have secured a foreign passport of some kind, you will be locked in until you get your tax problem under control. Bankruptcy. An alternate method for clearing the way is to file for bankruptcy. This will bring all of your creditors forward and settle all claims, once and for all. In the absence of fraud, all taxes owed on returns timely filed over 3 years ago, or in late returns filed over 2 years ago, are discharged in Chapter 7, liquidation, or 11, reorganization type of bankruptcy. A discharge will also apply to unfiled returns, for which returns were due more than 3 years past, or to late returns filed after the bankruptcy. If you file in Chapter 13, bankruptcy, wage earner plan, even fraud will not prevent discharge of taxes under that chapter. Chapter 13 is not available to anyone who has no regular earnings, or who has debts over $100,000 unsecured and $350,000 secured. However, one may file even though the claims of creditors, including the IRS, exceed those sums. He is entitled to dispute the claims. If he prevails against his creditors sufficiently to reduce the tax to the limits permitted, he may proceed with his plan. For the person with excessive debt, he would like to file what I call a Chapter 20 bankruptcy. First in Chapter 7 to reduce the debt to the allowable maximums, then in Chapter 13 to arrange installment settlement of what remains. After filing the bankruptcy, in order to satisfy the government's concept of good faith, one must file all past due returns. A homemade return is recommended. However, even if you do not file, if you have filed no returns, if the IRS fails to file a claim, demand discharge of taxes, which are not otherwise dischargeable. Literal language of the Bankruptcy Act will not permit discharge of current taxes, but that should not dissuade you from making the effort. Caution, be sure that you wait 240 days after any tax first becomes assessable in non-Chapter 13 cases to ensure dischargeability. The significance of bankruptcy is that under any form, the old taxes can be discharged, and the current taxes can be paid in installments over a period of 3 to 5 years. Installments which you determine, not installments imposed upon you by the IRS. Another blessing of bankruptcy is that the bankrupt can challenge the amount of tax claim due without first paying that amount. This would apply even to an amount previously adjudicated in the tax court, although not where the district court has made the decision. Then wait for the time limit to elapse before filing bankruptcy. By reason of the potential of bankruptcy, you may be able to make a deal with your creditors fully documented, executed, and enforceable, or with the IRS under their rules concerning compromise. Then you may be able to proceed with your state protection. You need only be sure that you have made adequate provision to comply with your agreements. If this is not possible, and you are unable to move forward with the debt burden which you have, select the proper form of bankruptcy and get a discharge. Forget about the damage to your credit. If you're really in such a situation, your credit's gone anyway. Let's talk a little bit about bankruptcy. One of my clients years ago filed bankruptcy, and one night I was thinking about, has he gotten all of his creditors listed? And I asked him the question the next day, and he said, no, they're all listed. I said, how about the Federal Reserve? He said, I don't owe them anything. I said, maybe you do, maybe you don't. Let's write him a letter and see. So we wrote a letter to Greenspan and asked him, what is our share of the federal debt per capita? About 2 weeks later, we got a letter from his office saying, thank you for your inquiry. Your share of the federal debt per capita is $22,500. That means, per capita means that every man, woman, and child on the face of the United States, the moment it's born, owes $22,500 to the Federal Reserve. I said, well, this is a presentment letter. It's a tax bill. This is a bill. Can you pay that? He said, no. I said, let's throw it in there. So we notified the Federal Reserve that we were found bankruptcy and they were creditors. And we filed it in court in Jacksonville, Florida. And Proctor was the judge and bankruptcy judge, and old Proctor was a grouchy old guy. He says, Mr. Stamper, you can't use the Federal Reserve in bankruptcy. I said, why not, Your Honor? They're a creditor. Here's their presentment letter. He looked at it. He says, anybody here from representing the Federal Reserve? Nobody there. He said, did you notify them? He says, yes, Your Honor, we did. Okay. And he put it in. That's the only guy I know in this country who has no debt to the Federal Reserve. So if you go bankrupt, get rid of them.
Mel?
Yes.
What about, for instance, someone like myself who's like way outside of all that?
Mm-hmm.
Could I go ahead and file a bankruptcy on my federal debt as well? Is it like that, something like that?
Sure. If that's all I don't know if
I don't own anything. So,
yeah. Sure. They're creditors. Get a letter from them, saying how much you owe, as far as your per capita, and then file for bankruptcy if you can't pay it.
I don't know what it would accomplish.
I'm not sure it accomplished much for you. I suggest you don't do that unless you use it if you're going to go bankrupt in a big way. I would throw that, because that way you get rid of all the debts. When you go bankrupt, usually if you owe your mother money, you put that into everything you owe, or ever will, or maybe owe, you put it in bankruptcy. One other thing, and we'll get it before I get them, I'll show a little document here. One of the most important tools you want to use is a Freedom of Information request. It's called a FOIA. Now this requires the government to give you whatever you're asking for. And I'm going to show you some stuff that we asked for. And in court, one of the things you always learn is you never ask a question you don't know the answer for. That's the first rule. And so I happen to know the answer, so I asked for certain documents. I asked for the Delegation of Authority Order. And I asked for 150-10, and they sent it to me, and 150-37, which are Delegation of Authority Orders from the Secretary of the Treasury to the Internal Revenue Service for the collection of taxes. Now, I got the documents, and you got to get certified copies when you ask for them, because you can't use non-certified copies in court. So make sure that they're certified. It costs you about $20 to have them certified. Well, we presented this to the bankruptcy judge, and we asked them for their authority. We didn't think they had the authority, so they gave us 150-37, which is their authority to collect taxes. And this is what it looks like. Department of Treasury order number 150-37, dated April 22nd, 1982. Now notice the seal on the right-hand side. Left-hand side is where the number is and the date. It tells you what his authority is. Now it was signed by Donald T. Regan, Secretary of the Treasury at the time. This is the current. This was the old one. Now the new one that they use today is 150-10. This is the one they currently use. Notice that the seal is different than the one you had before. The date is on the right-hand side instead of the left-hand side. It's a different format completely. Now, it wasn't signed by the Secretary of the Treasury for some reason, but the day that they made this one, they canceled it and put this one in its place. That doesn't make sense to me. He felt it important to sign one that we were going to cancel, but not sign the one that was effective today. But if you look at the very bottom of the page, in the old days, they used to put down the day the paper was manufactured. And so over here in 150-10 and 150-37, those dates are listed. 150-37, which the original delegation of authority was, the date the paper was manufactured was 2/81. So they made it in 2/81, and 4/22/82 they used it. So 14 months for stocking through the inventory system and use it. That sounds legitimate. 150-10, which is the current one they're using today. Now it's April 22nd, 1982 it was created. The date the paper was made was 11/85. So the paper was made 3.5 years after the thing was already the order. In other words, birds had nests in the trees for 3.5 years. Well, this is supposed to be an order. That's called fraud in its face. And if you get those documents and show them to the bankruptcy judge, say, I think this is a fraudulent order, Your Honor, because the tree obviously was still growing. It couldn't be a piece of paper. I've seen judges just close the thing up in frustration and walk out and dismiss their whole case. That's called fraud in its face. And these are the kind of things you want to get a hold of. And you do that long before you ever need them. You may never need them. Get them. Yes?
What was the reason they did that? Is there a reason for it?
There's a reason for it. I don't know what it is. They'll never tell you either. Yes?
Yeah, you were talking about getting your FOIA requests certified.
Yes.
Okay, I sent in several FOIA requests and never heard back. How do you get it certified?
Well, when the original FOIA request, you tell them you want a certified copy in your request.
Okay, again, when I sent in the request, I just never heard back. What's my next step?
They never answered.
There's an appeal. You go to the appeals officer, FOIA's appeals officer, and you file an appeal with him that you've requested this document. They don't have it. Now, if the appeals officer comes back and says, we're not going to give it to you, then you go to district court, federal district court, not the local one here in Medford or someplace else in the country. You go to the one in Washington, D.C. It's called the United States District Court for the District of Columbia. That used to be the old Supreme Court. In 1963, they changed the name. It used to be 2 Supreme Courts. And that's where you go. They will, I guarantee you, once you file it there, they will, for compelling order, they'll make them give it to you. You file for compelling order. They've got to give it to you. That's a mandate of Congress. They can't refuse it. In my hotel, I noticed that there's a briefcase in the corner on the desk, and you check in, you see them all the time, and you throw your business card in, if you're picked, you get a briefcase. I love those things. I love to go through and just pick out a whole bunch of hands and go back to my room, these cards, and go through them and see who's staying at the hotel with me. You find senators there, and I pull the senator's card out. If it's maybe an IRS, I'll pull that out. Federal Marshal, I like those. Secret Service, I like those. Maybe Oregon Department of Taxation, I'd take that one. And so you never know, if you're looking for information, say in Washington's reading room, you walk in and say, I'd like to have a certified copy of TD 150-10 and 150-13, and give them a card, Senator so-and-so. They look at it, yes, sir. Now, you never tell them that you're Senator so-and-so, because that would be fraud. You're not Senator so-and-so. But you can inadvertently give them the wrong card. And if they say, you're not Senator, no, of course I'm not. Why would you say that? And then all of a sudden you'll see the proper card. Here's my card. That's the wrong. I gave it wrong. Here, thanks. Give it back to me. You get a lot of information very quickly that way. I would take advantage of those things there.
Did you grow up in Jersey?
No, I was a cop in Chicago.
Can I take a look at those?
Sure. You pass them around the room. Okay, back. State options. In selecting an entity, first decide if we will simply hold, protect, and maintain assets, or if it will be used for business purposes. If not for business purpose, the tax consequences are less onerous, but it may not be an entity capable of bankruptcy. If for business purposes, be prepared to handle its records in complete compliance with the IRS requirements, unless it is a foreign entity with no jurisdictional exposure. Of course, regardless of tax exposure, the success of an entity depends to a significant degree upon the completeness of the records it maintains. However, remember that those records are private and immune from forced production, as business entities are regarded as privileged activities and they are subject to taxation, regulation, and disclosure of records. In addition, be sure that the entities are completely independent of each other. If they are not disconnected, they may be bunched together and treated as one entity as to their alter ego. Separate management, separate from yourself, proper capitalization, and complete records are your best protection against this danger. Avoid any claim that the management is a thinly veiled substitute for the debtor. A common problem with estate protection programs is that the programmer shows negligible sources for his opulent life. Common sense dictates that if you have a lifestyle and income which are mutually compatible, let the records reflect that you are paying for those things which you use. The fact that the payments will ultimately benefit a person or entity whose increase it pleases you is beside the point. If you haven't the means to pay for cash, borrow. If you just be sure that your income can support the interest on what you borrow. Ideally, give security on what assets, if any, you retain to secure what you borrow. Then incorporated organization. The unincorporated organization, called the Common Law Trust, Massachusetts Business Trust, or Pure Trust, Business Trust, or Incorporated Business Organization, is best called by the name Unincorporated Organization, or UO. This is the title used by the Internal Revenue Code to designate an entity which is not simply an association, which should be taxed like a corporation. If the UO operates a business, it will be called a business trust and may pay some taxes. However, if it's properly formed, it will be taxed on as a partnership, not as a corporation. This is the entity used by the super rich to cloud their interests. It can exist for the period of life, plus 21 years, and can be renewed time and again. By its use, like a corporation, probate is avoided. Death of beneficiary, trustee, or grantor has no effect on its assets, so there is never anything to probate. Ownership is manifested by an attachment listing the beneficiaries or by certificates of interest. There can be no gift or inheritance or other tax applied to the transfer of a beneficial interest, unless it's capable of valuation because it was acquired at one fixed value and sold in another. Since one purpose of an entity may be to avoid regulation and to minimize tax exposure, common sense will prevent value-fixing transactions. While the law generally recognizes the separate existence of the UO as an entity, in bankruptcy the entity has no recognition unless it is actually a business entity. For this reason, it may be prudent, though unnecessary, to register the UO under the fictitious name laws and pay for a business license. The particular virtue of this entity is that it arises by contract, which contract is protected against impairment by Article 1, Section 10 of the Constitution. This means that it is not an entity which arises by statute, so it's not taxed on that theory of law. In theory, at least, it is not subject to governmental regulation, as is a partnership or a corporation, or even a statutory trust. Regulation of the UO is a technical violation of the constitutional prohibition against contract impairment. Directly, the UO is the nature of a trust. The laws of contract and agency combine govern it. It comprises three essential parties: the grantor, who conveys assets to the UO, or the trustee thereof; the trustee who operates the UO in accordance with the terms and conditions of the instrument creating the UO, usually called the trust indenture; the beneficiary who receives the assets upon termination of the UO. And interim distributions, if directed by the terms of the trust agreement, are determined by the trustee in accordance with his authority. There's usually only one grantor. The grantor might be an individual or an artificial entity, such as a corporation. The trustee may be one or many. It might be an artificial entity. Beneficiary may be one or many individuals and artificial entities. Obviously, any of the three, or the UO itself, may be of foreign domicile. Because of the possibility that the UO might be taxed as a corporation, it is important to minimize the badges of that form. One such badge is an association of individuals. Having a single trustee helps to minimize the appearance of this badge, although a board of trustees does not create an association. Absolutely no direct or indirect management control to the beneficiaries can be allowed. Otherwise, there is a merger of interest, and an association arises, and the UO effectively disappears. Another severe problem is that the IRS will always want to pierce the UO and call it your nominee. Exchanging assets for certificates of interest would be deemed to be removing your assets from the reach of your creditors. Since the grantor trust arises when there is no trustee with an adverse interest, meaning an ownership interest, it would be impossible for one to create a trust as a grantor in which any relative has a beneficial interest. Therefore, someone unrelated to yourself must create any trust you use. In addition, unless you are completely debt-free and tax-clear, you must make any transfer or sale for fair value and let the trustee handle the issuance of certificates of interest independently. You must stay out of management or control yourself, or the trust will be treated as your alter ego. We have a question?
Yes, I do. You just said that if we're going to use a trust, we should not be the initiator, the setter-upper.
Yeah, let me tell you why that is. Because the farther you, some people they don't know a lot of people. They have very few friends and relatives or people that they trust. So they really have to create their own trust because they don't have any other option. And so I'd rather have to be as far away as you can, as arm's length from it as you can. That way they can't call it an alter ego or a grantor trust. So one of my students in Portland, Chet Davis. Have you heard Chet Davis? Chet's a nice guy, and we edit his name out. Anyway, he was asking me the question. I don't have any friends. I don't have any. What do I do? I said, I saw 3 people living under a bridge from my hotel room. Let's go ask them if they'd like to be your grantor. I mean, if they'd like to have you set up to trust as a settler. We call him a settler. We wanted to ask these guys, hey, would you like to make $300? The guy said, who do we have to kill? I said, nobody. Just come to our office and for a few hours and we'll pay you the money. And so they went to his office and sat down and he put together this trust for the guy on the computer and said, type this name in. He typed the name in. And okay, what's your Social Security number? He gave us his Social Security number. We applied for the EIN number with his Social Security number. And we gave his address. It was Route 42, I think, or whatever.
Side bridge.
Mile marker 605. And that's where he lived. Everybody has to live somewhere. Now, he may move bridges now. I don't know where he lives now, but he may have moved bridges. But that's completely legitimate. He's the one who created the trust. He's the settler. And he has no revisionary interest in it. So once he creates it and he transfers the assets to the trustee gives them the certificates, he transfers to the grantor, who transfers them back to the trustee. At that point there, he's never seen again. He disappears from the face of the earth.
So here at the office, we initiate trust activities for people. If the office were to be the grantor, or excuse me, the settler, is there any liability in that?
No, just for creating it doesn't give liability.
Okay.
As long as the document itself is legal, and believe me, legal as far as contract is a big stretch. As long as both parties agree to something, unless it is unlawful, the government has no control over it.
Okay.
Contract impairment is prohibited by the Constitution.
So let me flush that out a little more, please, for my own. If we were to act as the settler of the trust that we're setting up, and we would then name the client, whoever it happened to be, as the grantor,
Yeah, your client is the grantor who's giving you the assets. You set the trust up for him and transfer all of his assets to the trustee,
To the trustee.
who you've appointed as the settler. The settler appoints the trustee.
The settler appoints the trustee.
Yes,
right?
and at that point there, that he gives you the certificates of interest back to the settler, who gives them to the grantor, who gives them back to the trustee.
Okay, so the grantor gives the assets to the trust.
To the settler,
To the settler.
who gives them, turns them over to
Who
the
turns them over to the trustee.
Right.
Who gives the certificates of beneficial interest back to the
settler, who gives them to the grantor, who then gives them back to the trustee, who gives them to the beneficiaries or maintains them. Some beneficiaries never even know they have a trust. The trustee has all the certificates, but doesn't issue them out because that was the grantor's request, not to give them to them until later on. And the trustee is responsible for everything. He has total control. Many people, like Lynn Meredith, started selling trusts. Now, Lynn Meredith, you can put her name in, leave it in there if you want to, because she's going to jail for selling trusts. They were bad trusts. They sold trusts all over the place. And she's being prosecuted now for it because she says you can create your own trust, you can be the trustee of it, and you can also be the beneficiary, you can also work for it, and all the things you can't do in a trust, she was doing and telling people they can do it. Giving them phony bank numbers, for EIN numbers, giving them phony numbers that she created out of thin air. All these things they're doing are just illegal and unlawful. That's why she's going to jail, and she should go. She's damaged a lot of people. There's several other people in the country. I don't want to name their names because they have been prosecuted. I think they have been prosecuted. I think Joe Sweet was one. Dr. Joe Sweet. Now Joe Sweet, I guess he got himself a Doctor of Divinity degree from some magazine here in California, and $45, and became a reverend doctor who sells trusts. What he ever knew about trusts, I have no idea. But he used to create his own EIN numbers and put them on there for people, and that's bank fraud. And so you got to get the things done properly. You apply for them, have the settler use his Social Security number to get the thing. No connection with the grantor whatsoever if he lives under a bridge. That was just an example of what this guy did.
One other question in relation to that. A particular individual would be in fine standing if he was to settle hundreds of trusts in
Sure.
the fashion you talked about, no liability, no exposure.
No. You can have a professional settler if you want to, if that's what he does. He creates the trust, that's all he does, and transfers the assets to the trustee for the beneficial certificates, and then gives them back to the trustee again, or however they want to do it. But he has no revisionary interest in the trust whatsoever, none.
Correct, I see that.
Aren't many times the settlers never even indicate that they're just doing it?
No, the settlers are listed. If it's done properly, the settler's listed, because you really have to. He's the one who created it. Otherwise, it'll be called a grantor trust. Yes.
So, I think that I would have everybody's permission here to take this question a little further, because most of these folks are involved with us already. I just want to point out to everybody that we're exposing right now that we just learned something. I notice that Rob and I are engaging. I want to go a little further. Suppose, now the way we do it, the trusts are common law. You're familiar with the
Yes.
type pattern we do. They're common law trusts. There's no numbers attached to them. There's no filings. There's no registration outside of the private three-party contract.
Right.
Is it okay for the the settler, to be also the grantor in that when the trustee is someone else?
Again, you can. Nothing illegal about it.
Okay.
I'd rather keep as far hands away as I can. The farther you
Now
are.
remember, the two trusts set up, they're never filed, they're private common law.
I understand.
And the only thing that they do is own an LLC.
I see.
Okay?
Yeah.
And they own and manage that LLC in favor of the foundation. Okay? So our client, who's ordering the work to be done, would be classified as the grantor settler. But then there's a stranger in the trustee positions, and then the two trusts hire the IBC for management purposes.
I'd rather have one separate, another entity, call him a settler.
Got it.
Separate and complete and different. That was, the arm's length
to
is
go farther
farther,
away.
you're farther away.
So let me just, I want to just recap this, I'm writing this down because I want to make sure I got this right. I'm just going to go over this, what we just talked about. The settler creates the trust document. The grantor gives assets to the settler.
Yes.
Settler appoints the trustee. Settler gives assets to the trustee. Trustee gives the TCUs back to the settler. Settler gives the TCUs back to the grantor beneficiary.
Right.
Is that correct?
Yes.
Wait, grantor beneficiary?
Grantor or
Right.
beneficiary.
Not you can't be both. He
Right,
can't.
be both.
Right.
I got to work it. So.
Yeah.
One or
Well,
the
why,
other.
why would he give them back to the grantor, just in case they want to reserve them?
It's just right. And sometimes he gives them back to the grantor because then he's given his assets. He's got equal consideration, which are the certificates.
And then the grantor can give those certificates away.
Yes.
I will.
Transfer them to the beneficiary. Now, you were saying, what's the concern about having a grantor trust? You don't want it to be a grantor trust?
Well, again, the farther you are away from it, they'll call it an alter ego. So you're trying to hide your assets. That's what they'll call it. They always do. They call them alter egos or nominees, and they take it right to court, and the court just goes what they want to do anyway. So it's a one layer more that they can't argue because this guy had nothing to do with no revisionary interest whatsoever. Yes.
I have several common law trusts. They're certificate based. And
Yes.
I'm named as the manager. You suggest that can an artificial entity be the manager?
You can be a manager if the trustee must appoint you under contract.
Trustee appointed me under contract.
Okay, and he says, this is what you get paid for. He can fire you if he wants to.
Right.
As long as those provisions are in your contract, you're okay. I'd rather have no dealing whatsoever. I have 4 or 5 trusts in my life, and I have no revisionary interest in any of it. I have no control over any of it. But I use several houses. Anytime I want to, if I want to stay in this house today, I will. If I want to stay in the house tomorrow, I will. Drive that car, I'll drive that car. But it's not mine. And but I have use of everything, and I own nothing.
Do you have like a permission slip from the trust?
No. No, they call and have me arrested for trespass if they want to. But I have use of a lot of assets, but I don't own anything. And haven't for a long, long time. You know, the wealth, the people who have wealth know that the best way to keep it is to not have it. And use everything, but don't have anything. 'Cause really, it's kind of silly anyway, right? Because none of what we have is ours. We can't take it with us when we die. We leave it right here behind us. It's all God's anyway, always has been. We just use it while we're here. And that's a divine right given to us. But people who want to create wealth and build that, say, look what I did. Yeah, so what? Who cares? You're just as dead as I am, buddy. Okay, let's go ahead. To ensure the continuity of a trust, it is prudent to have successor trustees selected by the trustee when he is appointed. If there's any uneasiness in the grantor with regard to the integrity or future performance of the trustee or successor, the trust agreement should provide for a protector. This protector trustee must have the authority to approve the trustee's compensation, to move the trust to another jurisdiction, and to remove any trustee at any time without cause. This protector should not be either the grantor or any beneficiary. In addition, the protector must have no power to direct the trustee, or he effectively becomes the trustee himself. Sovereign trust. Now, this is what I decided to do for myself when I first found about the sovereign trust. Almost unique in America is an entity known as the sovereign trust. It was especially imported from England in the mid-'80s and has begun to be used here. The Queen of England and the Pope have this type. If it's good enough for them, it probably suits your purposes. Basically, it's a common law type of trust. However, it has no domicile because it is created in a place which is not limited within the jurisdiction of any particular government. Having executed in international waters or airspace does this. In a boat or aircraft which has joint ownership by citizens of different nationalities, preferably 3 or more. In addition, the trust may recite that the law of 3 or more nations governs it simultaneously. The effect is to create a multinational, non-domiciled trust. It incorporates both kingdom law and canon law. It is a form of trust used by English royalty and by the Vatican. It appears that this form of trust is utterly unassailable in any court. However, so far as is known, no court case has tested this viewpoint, as the Queen of England nor the Pope, to my knowledge, has been the object of a suit. Now, in Puerto Rico, for instance, it's very easy to do that there because the mode of passage between Puerto Rico, which is English common law, and Hispaniola, which is the island Hispaniola of the Dominican Republic, which is Spanish civil law, and then the other side is Haitian civil law. Those 3 types of law cannot ever work together. They're completely like oil and water. And they will never work together. So if you give them simultaneously, and you cite it from the mode of passage out there in a fishing boat, and the captain of the boat is the guy who notarizes the documents and signs them off. And the latitude, longitude that you've done it in, it's international waters. It is unassailable in any court. That's called international trust. And
Mona Passage?
The Mona Passage.
M-O-N-A?
Yeah, uh-huh. And you go down to Puerto Rico and get yourself a fishing boat, go out there and spend a couple of nice days out there fishing and come back with your trusts all signed and notarized by the
Do you suppose
captain.
I could hire a regular captain who's going back
I'm
and forth?
quite sure you could.
Gee, I have usage of property in the DR. I don't know it.
Okay, domiciled entity.
Thank you.
Well, it may be essential for your purposes that the estate entity be established outside of the USA. Be aware that other jurisdictions may present problems worse than those you fear may. Foreign seizure of assets is not uncommon, particularly Mexico. Treaties with the USA may exist, which could defeat your purposes. Your passport to travel may be expired and not be renewable. For many purposes, it might be sufficient simply to go outside the country to conclude your transaction and thereby avoid the sales tax. Since most states share tax information with the IRS, privacy is impossible for any domestic entity. Of course, if you have a sovereign trust, there is no problem of domicile. The only question is whether the trustee of such a trust is found within any particular jurisdiction at any time, thereby within the authority of the local government. Jurisdictions which have sufficient independent jurisdiction are physically sound, friendly, convenient, and compatible include Turks, Caicos Islands, Isle of Man, and Channel Islands. Tax-free jurisdictions include Turks and Caicos, Isle of Man, Gibraltar, Monaco, Jersey, Guernsey, Malta, and Panama and Bahamas. Turks and Caicos have the rare quality of allowing a corporation to insure bearer shares. Having the entity offshore provides tremendous protection. For one thing, neither an American court nor the government can make enforceable orders against the entity or its offshore assets so long as there is no domestic branch. For another, if you have borrowed money abroad and given a security interest in domestic assets, the foreigner can come into our courts and enforce his priority claim over other creditors with the IRS. However, the IRS has begun with maniacal prosecutions of anyone with offshore interests in the form of trusts or limited liability corporations. Choose carefully any offshore entity. Another benefit merits special mention. If you have sold property to one of the entities created for estate protection, you are certainly free to lease the property for fair value. This avoids the IRS claim that the transfer is just a nominee. As for the proceeds of the rents paid to the entity, these could be invested in an annuity offered by an offshore entity payable over 20 years or so. This consideration is clearly fair. The pay is beyond reach and has years to play with your money. Only the UO or its successor has any power to enforce the contract of annuity. If it is deferred for a period of years, there is nothing to enforce for that period of time. In addition, nothing prevents the annuity payments from being deposited in an offshore account. Once you have an arrangement of some kind with a foreign entity, it is simple and appropriate for you to move money offshore simply by paying the bills which the domestic entity incurs doing business with the foreign one. Money can be paid offshore to purchase corporate stock, annuities, or insurance policies. These purchased investments can be the source of borrowing money to capitalize a business, domestic, foreign, without a tax consequence. Tax factors. Be aware that at all times that withholding of amounts of up to 30% of income paid to a non-resident alien is required unless a favorable tax treaty is enforced. This rises to 35% when they transfer a property without paying gains tax on any increased value. Tax procedures. If the UO expends all of its income and expenses and distributions, it has no income to report and no tax to pay. If it does retain an accumulated profit, it will report it on a Form 1041. The tax rate applicable is that of a married person filing separately. The trustee can deduct the medical expenses on trust income both for himself and his entire family. Because it's usually a business entity, the UO should apply to Philadelphia for an ID number, which would commence with the numbers 52. There is no estate tax involved when the UO is used. The UO and the UBO business trust is the newest and most recently challenged entity by the IRS because it gives the privacy and tax reduction that drives the agents crazy. So I will drill a little deeper into the structure and benefits of UBO. Trustworthy trust. Most all of us have been or will either be directly or indirectly exposed to a judgment creditor. Obtaining a judgment against another individual or company is now big business. Attorneys advertise through TV, radio, newspapers, or even on park benches, encouraging everyone to think of someone they can sue. They even offer great diversity of ideas at no cost to the plaintiff unless the case is won. Sue for slander, headaches, injury, lack of disclosure, for disclosing too much. In addition to attorneys, the infamous IRS is well known for the atrocities and havoc that they play on the lives of families and businesses and companies. The IRS doesn't think twice to place a lien on a home, seize a bank account, or levy a person's wages. Whatever happened to the right to work state? What happened to life, liberty, and the pursuit of happiness? Under common law, all these things are absolute rights. Our government is leading us to believe that these are not really right, but a privilege for which we must pay an excise tax. Are we a free country or a police state? We are what we the people allow. The United States is bankrupt and has been since 1933, and we are all the scapegoat. Taxes, penalties, and interests are out of control and will get worse, never better. That's the way it's intended to be. Major financial institutions are being forced out of business, and the battle to collect money and assets from we the people continues at an ever-increasing pace. Recently, there was a card circulating around the IRS offices which said, "Seizure, fever, catch it." Many individuals have approached me only after judgment liens have been placed on their homes, bank accounts, and businesses. Although I'd like to help and occasionally can, it's usually too late. Your assets are a lot like an egg, where the contents are safe and protected until the shell is broken. Once the integrity of the egg is breached, the contents are vulnerable to the adversary, be it a snake or a hostile two-legged pinstripe suit. I have personally spoken to people whose lives have been shattered, whose homes have been levied upon, whose farms have been seized, and whose businesses have been ransacked by those organizations that act as though we are a police state rather than a country for and by the people. Don't put all your risk in one basket. Very wealthy families have used one of the greatest defenses we have for a great many years, generations. We call it the UBO, the Unincorporated Business Organization. It's not a typical trust as set up by an attorney. Attorneys are taught to practice statutory or equity law, not common law. Equity law, described by this one Supreme Court justice as equity is brutal. It takes away our fundamental rights because it's primarily contract law where the Constitution has no relevance, while common law allows for a great deal more privacy and protection. Let me give you an example. Corporate law, which is a form of equity or statutory law, allows an individual the right to contract with the state when setting up a corporation for the privilege of reducing personal liability. Among your obligations as a corporation are disclosure of all officers, a minimum tax required each year, double taxation. Any corporate earnings that are paid out as dividends to the officers are taxed once at the corporate level and again at the recipients. All financial records are subject to seizure and audit at any time without any prior notification. That can be our UBO trust. No yearly fee. One-time charge to set up the trust. Limited liability by virtue of the fact that the UBO operates as its own fictitious person. It can operate just as you do. Each trust has its own accountability and risk. Privacy. All officers and board of trustees do not have to be revealed. Your financial records are private and under common law require notification and a court order to be seen. Why don't more businesses use the UBO trust? My research has led me to consider that certain special interest groups in the 1800s were frustrated that common law did not give them enough control over individuals and businesses. One of our constitutional rights under Article 1, Section 10, guaranteeing an absolute prohibition against state interference, is our common law right to contract. It can work for us or against us. These special interest groups use this right to establish a new legal system, which we now know as equity or statutory law. To market their legal system, they set up or contracted with universities in the various states that allowed only those who graduated in their school of thinking to practice their law. These universities did not and do not promote common law, which is protected throughout the United States. So their graduates were limited to the state in which they were licensed by contract to practice. Equity law gives them, these special interest groups, greater power over individuals and businesses. Therefore, UBO trusts would not provide enough control by these special interest groups. Additionally, attorneys simply wouldn't make as much money. Since attorneys are not taught or encouraged to practice common law, they know very little about it. There are no universities that I know of that teach it. It's up to we the people to learn it and use it. We must know and practice our common law rights. Our forefathers fought and died for them. They will work for us when we work for them. Yes?
Had several questions lately from clients wanting to know how they can study common law. Is there a good source?
Yes, Blackstone's Commentaries. There's 4 volumes from the Chicago Press. They're $25 per volume. They're written in Old English. So Old English is a little difficult to read at first. The S's look like F's. But once you get the hang of it, after maybe an hour or two, you'll be able to go through it pretty easily.
And then you can read the Geneva Bible.
The Geneva Bible's next.
What was the name again?
It's
Blackstone?
Blackstone's Commentaries on the Common Law. And the Chicago Press, University Press, has those. And they're paperback. You can get them hard copy if you want. Paperbacks, they're $25 per book. And to have an understanding of common law, he was the authority on common law in England as it came over. And I think that's your first start. And then you go back, every time I go to a new state, I always try and go spend a day or two at the archives, state archives, and go back and I look at all the old filings from 1850 or 1860, and I go through all, from criminal as well as civil. And I spend weeks and weeks in the archives when I can and make copies of them because this is common law filings that these people used. And so you teach yourself the common law, which I did. It took me almost 9 or 10 years to understand it after going through all this work and research. But when you start seeing things that are there, these pearls of wisdom that are there, and they're like diamonds. You dig a diamond out. There's not many diamonds in a hill of dirt, but when you find one, it's very expensive. And that's the same with common law. You won't find them a lot, but when you do find them, boy, they're profound. And so here at Sacramento, I go down and spend a lot of time because Sacramento's got a wealth of common law at your fingertips, just by going down there and going through the old filings, making copies of them. That's an arduous thing. It took me 9 years of intense study in common law to finally understand how to use it. Because the common law is like a deck of cards. They didn't abolish it. It's still the law. It's the law in this country. But what they did, they red and blue deck, they took them, shuffled them together. So the statutory law created by the legislatures or the Congress, which is not common law, it's mere prima facie law, and then the common law, they shuffle them together. And so you can't know which ones are which unless you actually know where to look at in the statutes. Yes?
I understand that we're all corporations unless we rebut it, timely by affidavit.
Well, let me tell you my belief system as far as that.
Statutory laws only apply to corporations. Is
Let
that
me
not true?
Well, let me tell you what I think. Now, I may be true, I may not. I think this is how it works. When your person's born, they created what's called a certificate of live birth. Now, the certificate of live birth will be upper and lowercase letters. Your name will be spelled properly. Once the state gets that from the hospital, they send them over to them. They create a birth certificate. This birth certificate, all of a sudden, this capital name comes up, all capital letters. That's sent to under the Townsend-Shepard Act of 1932. It goes to Department of Commerce in Washington, D.C. At that point there, it's monetized. The Treasury takes this certificate, and they pledge the life up to 59 and a half years of productive life for taxes against this entity that they created, and also any property that it owns as collateral for our bankruptcy. So they can go ahead and issue their securities and get money from the Federal Reserve for it. So right now, if you send away to the FOIA request to the Department of Commerce for your birth certificate, they'll give you a copy of it. It's all capital letters. Now, your state ones probably are too, unless you're 1964, I think, was the departure date. Before 1964, your birth certificate will be upper and lowercase also. After 64, they all became capital. And so they created this entity that they created, and it's not yours. So one of the fallacy I find in the redemption program, when people take and file these UCC ones against their name, it's not theirs. It was created by the state. It had nothing to do with them. And so they're filing these things against the state-created entity that the state created, and they can make all the laws they want against this entity that they have. This is a corporation, a legal fiction.
But it's a jurisdictional issue.
It's a jurisdictional, absolutely.
Yeah.
It is a jurisdictional issue. But again, all these laws apply to it's legal what they're doing, but if applied against you, it's illegal, unconstitutional, and you've got to be able to challenge it. If you're not aware of it, you can't challenge it. If you don't know who you are, you walk up there and say, "Here I am." Well, dummy me, I'm capital letters. Here I am. Do what you want to me.
Copyright on that fiction.
No, it doesn't work. I've had lawyers who've tried that, and it doesn't work. It's not yours. You can't copyright something you never created. They created it. It's their creation, not yours. You had nothing to do with it. They created it.
And, we've heard lots of stories, success stories, about what happens when someone has attempted to close down all of the franchise relationships and then copyrighted the all capital letters, and we've heard many success stories about that.
You've probably heard some.
Because what they were doing was wondering who was going to be responsible for the use fee.
Yeah, I hear as in a legal sense, I hear the failures. I don't hear the successes. And the ones who I think I've heard several successes, but they're aberrant incidents that happen. In court systems, like O.J. Simpson went free. Now, we know that's an aberration. It shouldn't have happened. He certainly killed those people. We know that. We all know that. But those things happen. And those aberrant events that happen within law, the judges don't publish them. They're not published because they don't want to perpetuate something that's bad law. And so you're going to find a lot of these things that happen in this community because you'll find judges. Judges, I think, are lawyers that have a IQ of maybe 55. They become judges because they can't make it as a lawyer. And so they join the Rotary Club, they become elected judge, and all of a sudden they're knowledgeable in the law and their jokes are funny. Whenever I have a case, I always write a comprehensive memorandum of law. And you'll see some of these this week. is I go through these, I go back and do the research on the law as far back as I can go. 1776, if I go back that far, even beyond that, and some of them. I go back to Old English law. And I show the evolution of the law, how it applies, and what the law should be today, based upon all this records that we have. And so I give them to the judge so he understands what the law is. Because he doesn't know. Believe me, they're the dumbest lawyers in town. That's why they're judges. And they're still dumb lawyers. So you want to make sure you educate this guy in the law. So I always do a memorandum of law, and very comprehensive one, so he understands, and my opposing counsel knows he's got a losing battle on his hands. So the memorandums of law are very important. And I wish you had to use those later on.
Like a good friend of mine has a principle that he applies, and it's that if you work for the government, it's because you couldn't make it in the private sector.
Yes. Yeah, we'll take a little break.
ReverseSpeech.com?
Yeah, reversespeech.com.
And it's a downloadable file.
How does this work?
It's recorded. Once you've been told it all good. Talking to it and it plays
There's
back.
babies who can't speak yet. Doing baby talk.
Yeah.
You tape record them, and it comes back with actually saying things like.
They're
"Mommy,
composing
Daddy."
thoughts.
It's amazing. It's amazing because they're already speaking reverse speech at that age. I was following my little grandkids around every time I get near them and shut up.
I don't understand how that
My
works.
son won't get near me with it because he lies like hell anything. He never tells the truth. So I know that. He'll never be recorded.
This is for,
But how would that work? Because language varies from, I mean, is it the same as Spanish?
One mind.
Makes a difference. Makes a
Give
difference.
the answer in Spanish.
Yeah.
My earphones? Thank you. Okay, get back. We've been chastised. We're taking too long of a break here, so let's get back to this.
Okay, you guys.
Okay, there are many advantages to a UBO trust when used for personal and business affairs. Privacy in personal and business dealings, greater control over what you've acquired and accomplished, reduce exposure from potential lawsuits and claims from adverse parties, and to discourage sue-happy lawyers by maintaining an effective empty pockets program. Reduce liability when owning and operating a high-risk asset or performing high-risk professional services, thereby saving money on high-priced insurance premiums. Increase profits via reducing business costs, flexibility in creating personal and business planning, simplicity of doing business in this increasingly complex society, including the buying and selling of big-ticket capital assets, businesses, and real estate. Preserve and distribute assets at your sole discretion. Avoid probate and eliminate death taxes. Reduce or avoid federal and state income franchise taxes. The trust may develop its own credit and investment program to provide security and protection for the beneficiaries at retirement, and more. Having titles of property in your name greatly increases your exposure. Yes?
A couple of questions. You're talking about using the UBO for purchasing real estate. What are you going to use for as a government number for loans? What about FERPTA?
I would probably have a combination of different things. Like Gino's got a structure, like I think it's an excellent structure, where you have LLCs do a lot of the business opportunities for you, and you keep your trust separate without identification numbers.
And that law FERPTA also might come into play.
Yeah.
Is a UBO considered foreign?
No. It's common law trust.
Common law trust. So FERPTA says that if a foreign person or individual owns real estate in America, there's a 30% withholding on transfer. Does a UBO fall into foreign for that transfer tax?
No, it's not foreign.
And I guess also too, once you've got the asset in the trust, you don't transfer the trust. You transfer the whole body, or
The whole trust is transferred.
so one house in one trust, just transfer the beneficial interest certificates.
Right.
You know that?
A lot of people do use trust, UBO trust. For instance, I had this lawyer who was in my classes in New York, and one of our students was a very wealthy car dealer. He owned several franchises and a lot of tire stores, a lot of property. And he said, well, how can I use these trusts to protect myself? So what we did is we worked a year and a half on his particular problem, the lawyer and myself, and we put 26 trusts together for this guy. The first trust, like a clam. And inside it, the pearl was another trust and 4 tires. So it was funded, the corpus was funded with the 4 tires and another trust. inside the other trust was another trust and maybe a tire changer. After 26 of these clams, each one having a trust and some corpus in it, it got down to the last one, which had all of his assets. Had his businesses, and had his farms, and all this stuff, and the last one. So to get to them, they had to break 26 trusts. Each prosecution of a trust is about $150,000 the government must spend. They don't have that kind of money. They the federal government. So we just, like a clam, and the very last one, like opening a Christmas package, there's 14 boxes in it, and get down to the small one, that had all of it. So I don't think that he'll ever be challenged. And he didn't have to take his assets anywhere. He's right there in Middletown, New York. And he's tickled to death with it. So you use UBOs in many, many ways. Okay, having title to property in your name greatly increases your exposure to potential lawsuit. A creditor, by running a title search based on the Social Security number, can access your assets and target them. Properly placing your assets in a private UBO trust under its own employer identification number would help shield assets. This offers you a chance to bargain with legitimate creditors from a position of strength and have protection from those who are illegitimate. Remember, the more assets you have in your name, the greater the target you are. A UBO trust is a wonderful estate planning tool, a means of reducing taxes, protecting assets, and preserving privacy. The symptoms of growing bondage are all around us. Thousands are being victimized daily without the knowledge to defend themselves. Having ownership with your name and Social Security number attached to anything places you in a glass house as a target. The more you own, the more likely a target you may be for some frivolous lawsuit. A trust properly set up and managed can protect your privacy and property. Privacy is still a right until we give it up. The trust offers reduced liability from potential lawsuits and claims of adverse parties, and discourages sue-happy lawyers by maintaining an effective empty pockets program. Allow you to deal with frivolous lawsuits and judgment creditors from a position of strength without being victimized. This is another method of protecting assets which is gaining popularity, known as the corporate and sole. UBO trust can be used in conjunction with the corporate and sole for greater protection.
Mel?
Yes.
Before you go into the corporation sole, if I can ask one more question
Sure.
in relation to the UBO, and that is in relation to an IRS edict that came down a couple years ago internally, as you're probably familiar with it, essentially seek out, find trusts, and is basically innocent until proven, guilty until proven innocent. Seize what you can, and then force the taxpayer or non-taxpayer to attempt to reclaim.
I think the
right?
program was called Operation Phoenix, and they hired 2,000 of the best trust minds in the country from all the different trust companies. They hired these guys away from these companies, and their whole objective, for reason for living, was to break trusts. And they went around, especially the ones offshore. They started targeting them first. If they could locate them, they target them and try and destroy them. Many people were arrested and brought home, extradited out of Costa Rica. And we know some of the people.
Yeah.
And they're doing that because once it's offshore, they have no control. So they're desperately trying to stop these trusts. And so they'll say these are phony, like the Quantalus website, which is probably IRS website.
Right.
They knock corporations and souls, they knock trusts, UBO trusts, they knock all this stuff because they're trying to destroy people's concepts, because it's a sea change happening in this country. People are finally getting educated, and it scares them to death.
So my point is, I guess my question is, obviously we at Source here utilize trust in a structure. However, I see the wisdom in utilizing a trust simply to hold interest in maybe a statutory entity, but not to actually hold assets within themselves, such as a house. Since, even though it's completely lawful, we know that, supposedly, it's supposed to be protected by law, but they're on a trust-busting mission.
Sure.
And what do you have to say in relation to that? My
Well,
conclusion in that regard.
I would, number one, I would want to use a lot of things. First of all, if that was my property, I would probably have it in a trust. I also have somebody file a UCC1 charge against it and file someplace, tying up the property for some reason, giving a priority claim to that person, individual. Have a contract with somebody, and you breach the contract, he files UCC1 on you, and attaches your property. I would have leaned myself so bad that nobody could lean me. The IRS couldn't do it. You have to wait in line.
Sour in the middle.
Yeah.
Well, that raises one other question, and I haven't researched this myself, but I keep hearing that these days the IRS can actually take precedence over even a first lien holder?
No, they can't.
A
No,
second
UCC.
lien holder.
Second
First
lien
in
holder.
time,
Okay,
first
they can
in
be,
line.
they
Right.
can be second, they can supersede anyone behind the first.
Right. First one,
Okay.
first one's
First position.
sacrosanct.
Okay, first is sacrosanct, but they can get in second position regardless of how, okay, that's what it is.
Yes.
And now I've also heard that unless actual money has changed hands and there's some paper trail of that money changing hands, that the lien in court can actually be ignored. If some,
You can be challenged, not necessarily ignored, be challenged. But the fact is, if you have a lien on there, a good faith lien, you can't just go put a fraudulent lien on there. But you can have for instance, I could have a lease for somebody for 100 years at $1 a year, and it's still valid, as long as there's some exchange there, a valid exchange. But
We do lines of credit and do options.
well,
Alternative.
yeah, there's probably 1,000 ways. We sit here all day and never get on with this class. So let's pass on this, because there's a lot of good ideas out there, but I don't have all the answers. The only ones I have answers for is ones I've actually done. Okay, corporation soul. What is corporation soul? It's an unusual type of corporation consisting only of one person whose successor becomes the corporation on his death or resignation. Aggregate and soul. A corporated soul is one consisting of only one person and his successor in some particular station who are incorporated by law in order to give them some legal capacities and advantages, particularly that of perpetuity, which in their natural persons they could not have had. In this sense, the sovereign in England is a sole corporation. So is a bishop, and so are some deans distinct from their several chapters, and so is every parson and vicar. History. Now again, when I started doing research, I go back to the beginning, as far as I can go, to find out all about these things. And this is kind of a little bit of history on it. During the Reformation period in Europe, 1500 to 1550, the Church of England was in desperate financial straits. What got them in this difficulty has all been disregarded by history texts of this time period, lest it embarrass the Church and the English crown. The Bible had just recently been put to print. Only churches and the nobility owned copies, due to the excessively high cost of paper. The handwritten versions were outrageously expensive, procurable only by those with extreme wealth, such as churches, crowns, and the nobility. The freemen of the realm, primarily the tradesmen, were unsworn and unaligned. The market for the Bible was not the wealthy. They already had a handwritten copy, nor was it the tenants. They were far too poor to make the purchase. The market was the tradesmen, and the book was still so costly that it took the combined life savings of siblings to buy a family Bible. The other reason was that tradesmen were the market. They had also been taught how to read as part of their apprenticeship. Other than other families of the super rich and the priests, nobody else knew how to read. These men were overwhelmed when they read what Jesus commanded against swearing oaths in Matthew 5:33-37. This was news to them. For well over a millennia, they'd been trusting that the church, originally just the Church of Rome, but now also the Church of England, had been telling them everything they needed to know about that book. Then they found out that Jesus said, "Swear no oaths." Talk about a revelation. Imagine seeing a conspiracy revealed that went back over 1,000 years. Without oaths, there would have been no tenants laboring for the nobility and receiving mere subsistence in return. The whole society was premised on oaths. The whole society claimed it was Christian, yet violated a very simple command of Christ. In addition, the tradesmen had done it also, by demanding sworn contracts of indenture for apprentices and giving their own oaths to the guilds. They had no way of knowing oaths were prohibited by Jesus. They were angry and livid, might be a better term. The governments had seen this coming, but what could they do? Ban the book? The printing would have simply moved underground, and the millennia-long conspiracy would further be evidenced in that banning. They came to a better scheme. An unprecedented display of unanimity, the governments of Europe adopted a treaty. This treaty would allow anyone the state right of founding a church. It was considered a state right. The church would be granted a charter. It only had to do one very simple thing to obtain that charter. It had to assent to the terms of the treaty. Buried in these provisions, most of which were innocuous, was a statement that the church would never oppose the swearing of lawful oaths. Jesus said none. The churches all said, and still say, none except. The tradesmen left the Church of England, but with every new Reformed church still opposing the clear words of Christ, there was no church for them to join or found. But they could not establish a church, could not establish a church which followed Jesus' words, for that would have required assent to that treaty, which opposed what Jesus had commanded. With the huge membership losses from the Anglican Church, especially from men who had been the most charitable to it in the past, the church was technically bankrupt. It was not just the losses from the tradesmen. Other people were leaving to join the new Reformed churches. Elsewhere in Europe, the Roman Catholic Church had amassed sufficient assets to weather the storm. The far newer Anglican Church had not. The Anglican Church, as an agency of the state, cannot go bankrupt. It becomes the duty of the state to support it in difficult times. Parliament did so. They enacted a tax, a nice religious tax, and by current standards, a very low tax, a tithe of 10%. Nevertheless, Parliament made a deadly mistake in that the Quakers, primarily as tradesmen, recognized this income tax as a tax without jurisdiction, at least as far as they went. As been unsworn and unaligned, they pointed out they did not have to pay it or provide a return. Absent their oaths establishing this servitude, there was no jurisdiction, and they were right. Despite laws making it a crime to willfully refuse to make a return and pay this tax, none were arrested or charged. That caused the rest of society to take notice. Other folks who had thought the Quakers extremists suddenly began to listen to them. These men were keeping all that they earned, while the rest of the unsworn society, thinking this tax applied to them, well, they were out 10%. The Quaker movement expanded significantly. That proof once evidenced in the marketplace. Membership in the Anglican Church fell even further, as did charity to it. The taxes were not enough to offset these further losses. The tithe tax was actually counterproductive to the goal of supporting the church. If the movement continued to expand at the current rate, no one in the next generation would swear an oath. The Church of England, what assets it possessed, would need to be sold off, and what remained of that church greatly reduced in power and wealth. Like the Roman Catholic Church, the clergy of the Anglican Church were permitted to marry and raise families. The entire congregation, even the vicars and bishops, had been charged this religious tax to support the church. The hierarchy of the church, in agreement with the king, permitted the clergy to take vows of poverty, like the Catholic clergy, in order that they became exempt from taxation on their incomes. The fact that the clergy were exempt from the tax did not set well with the congregation, so the concept of corporation soul was established. Corporation soul permitted the bishop and the vicar of the church to become a church by making all income and property of the clergy technically belonging to the church. That concept in place, the clergy's tax exemption status was more palatable with the people. The benefits were enormous to the clergy, in that probate was avoided upon the death of the bishop or vicar, and the next in bloodline became the corporation soul, the church. All accumulated property at the disposal of the next corporation soul and their families in perpetuity. Application in common law today. In early American history, the patriarch of every household was legally considered the overseer of a common law corporation soul. Analyzing the historical context, it would appear that the U.S. Constitution's prohibition against the corruption of blood is the legal foundation and support for this concept. No law can restrict the right for children to inherit the fruits of the parents' labor. This is identical in context to no law being able to take away the right of future members of a congregation or religious order to use and enjoy the property of previous generations. The American Founding Fathers considered the family the basic religious unit of society. As a corporation soul, we are acting as a fiduciary for our grandchildren, and the family property is not ours, but belongs to the church, and the family benefits by using the property as if it were their own, in the furtherance of the stated mission of the church. The corporation soul is a private religious organization. It is not controlled by statute. However, it does interface with statutory law and is recognized by most state governments. Your corporation soul will make application for a UBI number pursuant to 26 U.S.C. Section 508 of the Internal Revenue Code. With that number, it can contract, open bank, and checking accounts. The corporation soul permits the individual a greater degree of privacy in their personal affairs, combined with the religious convictions which are in conflict with present-day statutory law, to still function with relative ease within our society. Corporation soul consists of one incorporated office and provides for a succession of office holders with no board of directors, no shares, no bylaws, and no other offices. This form of corporation grew out of a need for the Church of England and the Roman Catholic Church to find an orderly and secure way to hold the past title to church property and protect the clergy's personal assets. The modern corporation soul is a result of 40 to 50 years of common law experience. It's extremely rare that a court action involving a corporation soul will be prosecuted because the concepts have been tested for centuries and most all defects have been corrected. Why use corporation soul? Corporation soul is a legal entity that can hold property and protect that property from liens, levies, seizures, and confiscation due to the personal actions of the individual. This includes all assets, including homes, boats, automobiles, and other such property. When the corporation soul possesses property, it is as if the church owns it, not you personally. You are the overseer of the property. Only and upon your death, your successor will then manage the property of the church. This is similar to a bishop or other heads of organized religious groups. All assets will be owned by the corporation soul and will pass on to your family without probate or taxation. This structure is without inherent disadvantages of other corporations and entities. Law incorporates this corporation soul in order to give it legal capacity and advantages that other corporations do not enjoy, i.e. operational rule and statutory regulation. The government cannot dictate how a corporation soul is to operate, so it acts with limited governmental interference. Is corporation soul a legal entity? Corporation soul is to be formed for the purpose of acquiring, holding, and disposing of church or religious society property for the benefit of religion, for works of charity, and for public worship, and of property of scientific research institutions maintained solely for pure research and without expectation of pecuniary gain or profit. This description found in many state statutes. Some states specifically recognize corporation soul, but do not permit statutes to be written regarding them because of the First Amendment prohibition against government making laws respecting an establishment of religion or prohibiting the free exercise thereof. There exist explicit statutes in 17 states that describe corporation soul. There are functioning corporation souls in over half the states because of the rule of comity. A corporation sole is registered as a religious society with the Secretary of State of your state and the county recorder's office. The corporation sole's mission may be education, medical services, legal services, or whatever the religious society decides is worthy endeavor in its articles. Benefits of the corporation sole. Upon recording ownership of the property as a church, the corporation sole is entitled to all the consideration of other churches and religious societies. The church may buy, hold, and sell property, real and personal, with complete tax immunity. There is absolutely no statutory limitation on how much money may pass through the church or religious society. And corporate sole can be responsible to provide for all your needs: shelter, food, transportation, clothing, medical, etc. This occurs first by conveying all that you own and all future earnings to corporation sole. You make a record by recording a vow of poverty. This lets the world know that you are now a pauper and own nothing. If you work for someone or company, you do so on behalf of the corporation sole. None of these earnings are taxable because they are paid directly to the corporation sole. These payments are made without deductions, diminishments, or taxes of any kind. Do not become an independent contractor. One feature of religious societies is that they can accept vows of poverty by their members, i.e. monks, nuns, priests, and overseers. The IRS recognizes these vows of poverty. When one is under a vow of poverty, the physical objects in their possession are not their own, although it may be their job to look after and use those objects in a fiduciary capacity to the corporation sole, in the furtherance of the stated mission of the church. Thus, when you see a Catholic bishop chauffeured in a stretched limousine, he is still under a vow of poverty recognized by the Internal Revenue Service and not questioned or harassed by the government. Virtually all Catholic dioceses are structured as corporation sole. Establishment of corporation sole. To form a corporation sole, a church official secretary is elected or appointed in conformity with church constitution, canons, or articles. There are states which have statutes that require a church seal. In addition, they specifically provide for ownership of property in any state or any foreign country. Provides for smooth tax-free transfer of title of property. You will be provided with a 9-digit federal identification number to open a checking account for the corporation sole. However, because you will be the signatory for the corporation sole, some banks require your personal Social Security number to verify through the banking commissioner's office assurance that you personally have not been involved in banking or checking fraud within your state. You will find that not all banks require your Social Security number. You may give it to them or refuse to go to another bank if you wish. It's not mandatory by law for them to require it. This is strictly a policy of the bank you choose. Title 5, 552A prohibits the bank from denying you a privilege or a benefit for not revealing your Social Security number. Many banks have been sued for denying that benefit.
What about the Patriot Act? Does that change that?
Well, again, they probably like to say it does, but later on this week you'll find out why it doesn't change it. The Patriot Act is hideous, but it applies to U.S. citizens. And we'll see how that works as far as you're concerned.
You're going to go into that?
Yeah, we will.
Because we've virtually, we're now seeing that foreign jurisdictions, banking institutions in foreign jurisdictions with corresponding relationships with the Federal Reserve require Social Security numbers now. So we're having Latvian banks requiring Social Security numbers on foundation accounts set up in Panama.
Yeah, the Patriot Act is going to destroy a lot of our concepts of freedom we've had for a long time. It's going to change and modify them. And the only way that we'll ever change that concept is if we go to court and challenge it. When it happens to us, we got to take them to court and see what happens. Unless we do that, we'll never know. They'll continue to do it and bully us into thinking we've lost that right when in fact we haven't. We've acquiesced it. Okay, normal legal procedure when a corporation sole finds itself in court is for the Holy Bible, a 1611 King James Version, non-copyright. The Constitution, the canons, and the articles of the church replace the state statutes and rules of court. If a church regulation covers a particular situation, the church regulation takes precedence over the state statute, rule, or procedure. Since the government has no power over any free church, all enforcement procedures must use the rule of the church. That being the case, the arguments of corporation sole should be expansive enough to deal with the above legal requirements. Religious society's property that is in the custody of the overseer cannot be taken by a court for satisfaction of personal claims against the overseer, because the property is held in the overseer's fiduciary capacity. Corporation sole is required to maintain meticulous records of dealings. However, it is charged with never divulging those records. Most Catholic dioceses consist of many corporation soles by one incorporated office of a bishop. Each building or automobile may be in its own corporation. The reason is purely to limit insurance liability. Pure trusts can also be used in this capacity, which are owned and not controlled by the corporation sole. There are no annual renewal fees for corporation sole, as there are with most trusts and other types of corporations. Future expenses will include only the cost to the county recorder every time another person replaces the person occupying the office of overseer to the corporation sole. The name that you use is important. It will describe the organization and the visions that you have for your corporation sole. A name should reflect an image of your intent with the use of fellowship, brotherhood, services, alliance, ministries, sinner awareness, health, and or the name that would be used to describe the following titles: a church, synagogue, mosque, or other name related to the religion practiced in them. Do not use your personal name. Applying for permission for exemption under 26 U.S.C. 501c3 avoids the natural immunity against regulation found in the First Amendment to the Constitution, as well as the Internal Revenue Code at 26, Section 508. The corporate sole is by nature a form of limiting liability within the assets of the corporation. The Washington statutes of corporate sole stipulate that the property held is in trust for the membership of the organization. This makes this kind of corporation function as a trust. In fact, the Oklahoma statutes describing corporate sole are found in that state's trust successor provisions, with the waiver of the rule against perpetuities. One guaranteed way to fail is an attempt to avoid taxation is to work for W-2 wages and donate 100% of your income to the corporation sole, of which you are an overseer. In cases like this, there is a contractual obligation not to exceed a certain percentage of one's income in charitable contributions within the taxing statutes. In addition, the IRS justifiably claims that the corporation sole is an alter ego for the W-2 wage earner. It liens, levies, and seizes all the assets of the corporation sole. The best way to avoid this snare is to never work for W-2 wages, but if you do, stay within the guidelines of the IRS when donating to the sole. You may use other tax strategies for lowering the tax bite. Corporation sole can be engaged in any lawful occupation, business, or profession. All earnings from the lawful endeavors are exempt from income tax. In fact, no state or federal tax returns are to be filed. Now, I always tell people when you start doing this stuff, if your mission out there is supplying milk, if that's your mission, supply all of God's children with milk, fresh milk, wholesome milk, then you want to make sure that you state that's what you're doing. Now, you can't open a 3-story whorehouse, those kind of things, because they're against God's law. And you must follow God's law. In my corporate soul, if you're not a Christian, I don't want you buying it, because mine's for Christians who happen to believe in God and His power. If you want to just avoid taxes and stuff, find somebody else's. There'll be plenty of people out there to sell you one. I won't. I create a corporate soul for my students only. I don't go out there and retail them. I don't sell them on the internet. I don't want them doing it. I want people who are Christians, who believe in the concepts, to use their God-given exemptions from these things. That's why I created it only for Christians. If you don't believe in God, don't buy mine, please. And again, I made the prices for mine so people can afford them. And what I would say don't do is don't give them to every friend, every Tom, Dick, and Harry you pass, and don't make a living out of this. Don't start selling my corporate and soul to people you meet and make yourself a business. Get yourself in your own business. Leave mine alone. I do these things for my students and my students only, and that's how I sell them.
We often get questions about corp souls here as well. And usually what I do is I go through this little scenario here where you say what it is and what it isn't.
Yep.
I forget where it was, 21 I think it was.
Yep.
Where, anyway, yeah, corporation souls formed for the purpose of acquiring, holding, yada, yada, yada. I start asking them questions, and every single client so far has realized just by me asking them those questions that, no, in fact, I'm not involved in corporation soul. I couldn't maintain that without being out of integrity.
Yeah, so my corporate soul, I'm kind of like the Pope. I ordain all my new overseers in their corporation souls. And so if they start looking for the source, the fountainhead, it would be me. I'm better prepared to defend myself than you are. So I'm the one who ordains you as the overseer, and I appoint you as overseer and ordain you. And mine's called, my name is on every one corporate soul, so always the same. No matter if I have 100 of them out there, they all have 100 of them. I'm the one who created the corporate soul. So if they come after me, I'm better positioned to defend myself than you would be. That's why I did it that way. It looks like we're a large organization, when in fact we're not. But it looks like we are. Okay, taxation is the only means for governments to work corruption of blood, because no law may impair the obligation of contracts, and when one places their family's property under contract, mortgage or otherwise, the corruption of blood provisions of the United States Constitution no longer protect property. The corporation soul has worked well for 450 years, and there's no reason to suspect that it will not function the same way for you and your family. Case law analysis of corporation soul. The fact that the modern American corporation soul works satisfactorily is perhaps best illustrated by the relative absence of recent cases carried to the appeal level. Corporate structure is seldom at issue, but the cases tend to run the gamut from torts, contract, civil procedure, piercing the corporate veil, workman's compensation, taxation, eminent domain, estates, and simple fraud. Property disputes are relatively rare, perhaps because there would be First Amendment implications for most corporations and souls. Corporations and souls seem to have a settled existence. There have been no rash of new legislation, nor have there been any repeals of earlier laws. The most legal disputes involving a corporate soul would be simple torts involved in insurance settlements at the trial level. There may also be reluctance for potential plaintiffs to sue an officer of a church or for officers of the church to permit disputes to go to trial. Special circumstances. 8 additional states have circumstances meriting comment. The constitutions of Virginia and West Virginia specifically specify that no charter of a corporation can be granted to any church or religious denomination. At least one commentator attributes this prohibition to the influence of Thomas Jefferson and James Madison. Although the tradition of church-state separation in Virginia may indeed be traced to the 2 former presidents, the constitutional provisions in Virginia dates to 1851, long after the death of both. West Virginia courts have acknowledged that the provisions in that state is descended from Virginia. While these constitutional provisions pose no problems in the titles of church property in either state, they obviously preclude a corporation soul. An article in Kansas Constitution which required title to property of religious corporations to be vested in elected trustees was repealed in 1974. Connecticut has a provision in its corporation soul that gives the local archbishop or bishop special powers and trusts if a Catholic parish corporation violates or surrenders its charter. The courts have interpreted this provision to mean that if the charter is surrendered, all the property vests in the bishop and his successors as a corporation soul. This section provides emergency powers that are not normally required. Oklahoma allows for trust succession in the name of an ecclesiastical office. Vermont, in contrast, specifically forbids any such succession. Finally, case law in Arkansas and Florida also deserve attention. The Supreme Court of Arkansas in dicta has recognized the Roman Catholic Bishop of Little Rock as a corporation soul without any special act of the legislature. The Florida situation is even more compelling. The Supreme Court of Florida has repeatedly held that a common law corporation soul is full force and effect in Florida. The court relies on the fact that the common law has been adopted in Florida and remains in force unless explicitly or impliedly repealed by the organic or statutory law. This unique position initially attracted journal comment, perhaps because it seemed contrary to the earlier United States Supreme Court position. A federal corporation soul. Only rarely has there been mention of a federal charter for religious or quasi-religious organization. When Congress voted in 1811 to incorporate an Episcopal church in the District of Columbia, President Madison vetoed it. His veto message, the President implied that a charter of incorporation was, in some sense, an approval of religion, in violation of the Constitution. More than a century later, when incorporation was so common, the Congress and the President took another view. In 1948, the Vatican completely severed the Archdiocese of Washington from the Archdiocese of Baltimore. The new Archbishop of Washington, with the help of President Truman, sought to have a corporation soul established by a framework for the new ecclesiastical territory. Congress complied by passing a private law that established the Archbishop of Washington and his successors as a corporation soul. More modern form. A number of authorities warn against confusing the corporation soul with a modern one-person corporation. In fact, courts have held that a stock corporation is not automatically transformed into a corporation soul simply because one person has purchased all the stock. It is possible, however, to structure a one-person corporation in such a way that it will closely resemble a corporation soul in operation. In fact, the Roman Catholic Diocese of Wilmington is so structured under the general corporation laws of Delaware. The Wilmington Diocese is not incorporated in the terms of the Delaware Code of Religious Societies and Corporations. Rather, the diocese is incorporated under the general corporation law, which already contains provisions for a board of one, for non-stock operation, and for formation of a closed corporation. By carefully writing the bylaws and by addressing the problems of succession, the Roman Catholic Diocese of Wilmington has fashioned a corporation that contains all the advantages of the corporation soul in a state that has no regular provision for one. In summary, from historical beginnings with King Saul and King David, corporation soul have been many transformations. From its quaint operation in English law, the corporation soul has established a modest yet solid foothold in the United States. In churches with a hierarchical structure, and particularly Roman Catholic Church, it has been a secure method of both ownership and property and daily operation. Most dioceses today incorporate each parish and institution separately to limit insurance liability. Corporation soul thus becomes a holding company with multiple subsidiaries. In a society characterized by religious and ethnic pluralism, the corporation soul has provided a useful legal option, well adapted to the needs of certain groups. Corporation soul has arguably made a greater contribution in the United States than in its native land. Corporation soul is destined to become a continuing part of American law for years to come. Now, below is all the different cases I found, and again, I could only find 37 the times it's been challenged in court. Every time it's been challenged in court, an appeal, they've won. The corporation soul has won, and the government has lost. So even in a fraud case, San Luis Obispo case in California, even in a fraud case, they upheld the corporation soul. So it's powerful. That's why the IRS is so vehemently trying to destroy it, this concept now. Okay, we are not in the business of establishing trusts or incorporating souls. However, many of our students have asked for them, so we've developed a UBO incorporating soul, which has to date not been challenged by the Internal Revenue Service. If you're interested in this package, inform your instructor for information. Now, if you're interested in this stuff, get a hold of Ralph sometime this week and tell him you're interested in it, and he'll take the information you need and tell you what the costs are, and he'll set them up for you. I don't do that myself. Ralph and his wife, they do that on the side. Section 2, what is sovereign? How do I become one? There were 3 blind men who were asked to describe an elephant. The first blind man carefully inspected the trunk of the elephant and quickly determined that an elephant is accurately compared to a snake. The second blind man, after much scrutiny of the elephant's tail, announced that an elephant is indeed more closely identified as a rope than anything else is. The third blind man, after a laborious inspection of the elephant's leg, determined that no, an elephant must be best described as resembling a tree trunk. What is 3 blind men describing an elephant, or a federal judge asked to describe your citizenship status? No one is so blind as those that will not see. People, person, or citizen, which one are you? As Americans, we are socialized to believe that we are all citizens of this great nation we call the United States of America. Quite frankly, most Americans are pretty emotional about the issue. Try telling your neighbor who fought against Hitler in World War II that he's not a citizen of the United States and see what reaction you get. The problem is that the people who write laws don't write them in the same manner that you and I speak. Laws are written to achieve certain goals, and the words used within laws are selected to achieve those goals. Sometimes the goals are legitimate, and the language that is used, while confusing at times, is necessary to achieve that goal. Other times, confusing language is used for no other reason than to obscure the truth from the casual reader. The issue of citizenship is no less clouded by such use of language than is in the other area of law. Definition of words or legal terms must be sought out diligently, and the context in which they are used always carefully considered. In the Constitution of the United States, the phrase citizen of the United States appears. Because this phrase appears within the Constitution, not a statute, the meaning of the phrase is determined by the meaning intended by those who wrote and signed the Constitution. If the intended meaning is manifest, there is no power on earth, including that of a criminal in a black robe, that can alter the meaning of the phrase. The meaning of the phrase citizen of the United States is well understood. That phrase is shorthand for the sentence all citizens of the 13 independent nations called states that are party to this Constitution. The important element that you should understand is that the citizen of the United States, spoken of in the Constitution of the United States, is more properly and accurately a citizen of the state in which he lives. The phrase citizen of the United States is actually a euphemism, used for convenience and brevity and not a legal title. After the Constitution was signed by all the states, the federal government began acquiring territories. At the time, these territories were limited to the lands west of the established boundaries of the states and lands not claimed by the states. People born in those federally held territories by parents who were not citizens of a state became de facto citizens of the United States, although at that time there was no statutory authority for such a thing. International law had and still has a long-established doctrine that, absent any extenuating circumstances, a person is a citizen of the national jurisdiction or sovereignty in which he is born. Federal territories were outside of the sovereignty of the individual state governments and within the sovereignty of the United States government, hence the de facto status as a citizen of the United States. This principle also applies to persons in Washington, D.C., which is under the exclusive sovereignty of the United States. For the sake of clarity, we use the lowercase c for citizen of the federal government and the uppercase c to denote citizen of the state of the Union. It should be noted that citizens of the United States are not the people who created the states, then by state action created the federal government. These federal citizens are not parties to the Constitution and therefore did not have legal claim to the same rights, privileges, and immunities that state citizens did. One should take careful note that the citizens of the states of the Union are the only citizens who possess all the rights, privileges, and immunities spoken of in the U.S. Constitution, plus whatever additional rights are secured to them by their own state constitutions. At the end of this section, you will see federal and state court cases that clearly show that the rights of one class of citizen are thoroughly different from the rights contractually granted privileges of the other class of citizen. This distinction in this class of citizenship continued without significant comment or concern until the end of the Civil War. Although the Civil War was not fought over slavery, despite what you were taught in public schools, the end of the Civil War nevertheless brought about the end of involuntary servitude and slavery in America. Prior to the Civil War, the southern states did not recognize blacks as persons who could become citizens of their states. In fact, it was well understood by the citizens of these southern states that when their state constitutions protected the right to own property or chattel, the right including holding slaves. That was actually what the framers of these southern constitutions had intended, and so that understanding was accurate and factual. After the South lost the rebellion, the United States took the opportunity to free the slaves. This was easier said than done because the constitutions of the southern states hadn't changed a bit just because the South had lost the war. Their constitutions still did not recognize blacks as persons who could retain citizenship. Prior to the adoption of the federal constitution, states possessed unlimited and unrestricted sovereignty and retained the same even afterward, except as such was surrendered to the federal government, or they were expressly prohibited from exercising by the United States Constitution, the Blair versus Ridgely. Congress was faced with a difficult dilemma. It wanted the freed blacks to become citizens, but there was nothing in the U.S. Constitution that gave Congress the power to alter the constitutions of the southern states. The best Congress could do, in an immediate sense, was to consider the South under military occupation of the United States, which it was, and recognize that as such, the southern states came within the authority of Article 1, Section 8, Clause 17 of the U.S. Constitution. What this meant was that as long as the southern states were held as the defeated foe, Congress could pass legislation that would operate within the area known as the southern states. However, in the future, when Congress would restore the southern states to their former status as regular states of the Union, all such federal legislation would cease to operate in the southern states. This meant that Congress needed a two-phase solution, the first phase being the enactment of federal laws to operate within the occupied territory, and the second phase being a constitutional amendment to secure the principles of those laws, even after the laws themselves lost authority in the southern states. It should be noted at this point that although the slaves were now free and had been born in a state of the Union, they still were not citizens of that state. In short, they had no citizenship at all. Under long-established doctrines of law, a person who is not a citizen of a place in which he resides is an alien. This legal position of the freed slaves was tenuous. Yes, they were free, but they were aliens to the land of their birth and thus not entitled to the same rights, privileges, and immunities as citizens. Although defeated in battle, the people of the South were not yet ready to capitulate on the slavery issue, and they moved quickly to use the alien status of the blacks against them. Almost immediately after the surrender of the Confederacy, many southern states started enacting black codes. These laws were intended to operate only upon persons not citizens, a phrase read out of Dred Scott versus Sanford, and thus effectively limit the newfound freedom enjoyed by the former slaves by requiring them to apply for licenses to do anything from holding a job to hunting for food. Because the southern states were under the exclusive legislative jurisdiction of Congress at this time, any state or local laws that conflicted with federal law would immediately become void and unenforceable. Congress moved quickly to quash the black codes. In rapid succession, Congress passed the Enforcement Act, the Freedmen's Bureau Act, and the Civil Rights Act of 1866. Collectively, these acts prevented the enforcement of the black codes and simultaneously imbued the freed black slaves with federally granted privileges they are euphemistically called rights. It is in the Enforcement Act that we first see the phrase citizen of the United States used as a legal term, embracing only the recently freed black slaves. This term is then used again in both the Freedmen's Bureau Act and the Civil Rights Act of 1866 in the same limited manner. It should be noted at this time that the phrase citizen of the United States has been used for nearly 8 decades before the Civil War, but always to speak of persons within federal territories. This was the first time that Congress had used the phrase to denote a person who had been born within a state of the Union. Congress could only apply the term in this way within federal law at that specific point in time, history, because the South, where the freed blacks lived, was federal territory, as long as it was being held by the United States military as a defeated foe. Phase 2 of Congress's plan was to put into action with the drafting of the 14th Amendment. Here are its pertinent parts to this discussion. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within this jurisdiction the equal protection of the laws. What's the significance of the word person in law? The Congress and the state legislatures are cognizant of their delegated authority given by the sovereign body politic under the federal and state constitutions granted them by we the people sovereign, and are specific when legislating law for the sovereign body politic and for subjects of the federal government. In order to gain control over us, we the people, they use word art, and by definitions such as person, including states, etc., they begin stripping away our basic fundamental rights by sophistry. And they depend upon your apathy of government for their success and the general obscurity of knowledge regarding our status versus the citizen subject to the district. Person, in general usage, a human being, natural person, although by statute term may include labor organizations, partnerships, associations, corporations, legal representatives, trustees in bankruptcy, or receivers. Black's Law Dictionary, 6th edition. There are 2 types of persons described. one, a human being, a natural person with natural rights, and two, may include artificial entities or legal fictions with legal rights. Significance in our jurisprudence. The word person, in its primitive and natural sense, signifies the mask with which actors who played dramatic pieces in Rome and Greece covered their heads. These pieces were played in public places, and afterwards in such vast amphitheaters that it was impossible for a man to make himself heard by all the spectators. Recourse was had to art. The head of each actor was enveloped with a mask, the figure of which represented the part which he was to play. It was so contrived that the opening for the emissions of his voice made the sounds clearer and more resounding, a vox personabat, when the name persona was given to the instrument or mask, which facilitated the resounding of his voice. The name persona was afterwards applied to the part itself, which the actor had undertaken to play, because the face of the mask was adapted to the age and character of him who was considered as speaking, and sometimes it was his own portrait. It is in this last sense of personage, or the part which an individual plays, that the word persona is employed in jurisprudence, in opposition to the word man, homo. And when we speak of a person, we only consider the state of the man, the part he plays in society, abstractly, without considering the individual. This Bouviar's Institute's notes, number 1. We'll stop right here for a second and discuss this a little bit. So, if you take the word in per se and persona, a persona, as we now understand, was a person, which is an artificial entity. And so when we contract with government or with anybody, we put a different face on, a different mask. And so when they bring you before a court, they're bringing these artificial entities before the court, which they have jurisdiction over, but not the actual person. But because you have a contract with them, you have accepted another mask and covered up your natural identity with this mask. And these adhesion contracts, we have many of them out there. We start looking about how many contracts do you have with government, state and federal. My goodness. As a Marine Corps officer, I had to realize I had to get rid of that contract. So it's something called a non-pro-tunc affidavit, nal for nin. So in law, if you make a mistake, you have an obligation to correct that mistake. So others don't rely upon your mistake to create their rights. So you have an obligation to correct it once you identify you've made a mistake. So if I made a mistake and signed something inadvertently I didn't mean to sign, I want to get rid of that mistake and correct it. So you send the entity that you made a mistake to a non-pro-tunc affidavit saying, hey, I made a mistake. I'm sorry, I did this. That's dumb, stupid, but I won't do it again. For instance, when you do a 1040 form, you've all done them in this room. On the bottom of it, on the very top of it, on the top right-hand corner, there's OMB number. That means Office of Management and Budget. And that number identifies what the form's for. You check it out to see if you write a request to the director of the OMB and say, what's this number for? They'll tell you it's for Virgin Island residents. Now, if you don't live in Virgin Islands, that's certainly not the form you want to use, right? If you know that and you still use it, that's fraud. That's a felony. If you use a form not for you, that's fraud. That's a felony. And the bottom of it says under penalty of perjury. Well, how can you be under penalty of perjury? The only way is to be under oath. If you're not under oath, or oath of office, you can't sign that because you're not under oath. Therefore, you can't be on penalty of perjury. If you do sign it, that's a technical perjury because you're not under oath. And you're saying you are. So that's 2 felonies to fill one of those forms out. So obviously, you can't do that anymore. Not just putting you in this position, now you know that, you can't sign one from now on. So I'm not sure what people are going to do this year. But you can't use them. Yes?
We had someone tell us a story. She went through all this stuff and she was convinced that she had no filing requirement, but she was still afraid. So she did everything, wrote out the check, and sent it in without signing 1040. They sent it back to her and said, sign it. We can't cash your check. She sent it back. I can't sign it. They called her up. Why can't you sign it? Well, I don't understand. It says true, complete, and correct. Penalty of perjury. I don't understand the tax law. Every time I call one of your agents, I get a different answer. There's no way I can sign this without, being a lie. Well, you have to sign it. And they sent it back to her. And she sent it back. I can't sign it. Went back and forth 4 times. It's been 5 years. They never cashed her check.
It's remarkable. I've been doing this now for 25 years. And I send them a statement every year. And say, it says, 6011 in the code says, anyone liable for a tax must file a statement, list, or form. Now I say, I don't think I'm liable for a tax.
You're making sound.
Oh, okay. I don't think I'm liable for a tax. However, to avoid any sanctions, I'm going to file the statement in compliance with 6011 of the code. I can't file a form because I don't know of any form for me. I've looked at the 1040 form, and the OMB number is for Virgin Islands. Since I don't live there, I can't sign that. And it says a penalty of perjury. Since I'm not under oath, an oath of office, I can't sign that either. Please furnish me with a proper form, and I'll be more than happy to fill this out. And so 4 or 5 times in there, I tell them I want to do this because I do want to do it. If there's a form for me, I want to pay my taxes. If I have something I'm subject to, I want to pay it. So I tell them in law, to prosecute you on criminal cases, there's 2 elements they must prove. One's called the actus reus, which is the act of doing something illegal. And one's called mens rea. Mens rea is a culpable intent. So I've established that my intent is to obey the law, not disobey it. Because if I did these other things, I'd be breaking the law. And I tell them in my statement every year to go ahead and give me the proper form, and I'll fill it out expeditiously and get it back to them. Well, I never hear from them, and I've been doing this now 25 years. So I think that I'm complying with the law. And again, if I have a tax, I want to pay the tax if I owe it. I'm not trying to avoid any taxes, and neither are you. If you owe it, pay it. I don't have any trouble paying taxes at the gas pump. They charge it to me, I pay it. Buy a tire, I pay it. Buy a bag of flour, I pay it. I pay excise tax all the time. Those legitimate taxes, I'll pay them. But I want tax. If you have a tax for me or a form, please show me identify the tax I owe and the form to use, and I'll do it. I'm not trying to do anything. I'm not trying to violate the law. Neither are you. Okay, as you can see from the definition of Bouviar's, in our jurisprudence, the part a person plays in society, the mask he wears, determines the natural or legal rights he may or may not have and the jurisdiction of the different courts over his persona. Article 3, Section 2 of the Constitution of the United States defines the jurisdiction of the courts. They are law, meaning the common law, with all constitutional protections, equity, admiralty, and maritime, meaning contract law, private and national law, with no constitutional protection, and the common law has jurisdiction over the natural person, the mask, by the use of Article 3 courts. The remaining jurisdictions have jurisdiction over the legal fictions, the mask, the non-natural persons, under Article 4 courts. A natural person can change his acting role in business and assume a different mask if he, for instance, enters into a partnership, corporation, or contract. He may still be a living soul, but his status mask under the Constitution has changed to that of a legal fiction or straw man corporate mask, and the court's statutory jurisdiction over the straw man has now presumed. Section 2. Representatives shall be apportioned among the several states according to their respective numbers, accounting the whole number of persons of each state, excluding Indians, not taxed. But when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officer of the state, or the members of the legislature thereof, is denied to any of the male inhabitants of such state, being under 21 years of age and citizens of the United States, or in any way abridged except for participation in rebellion or other crime, the basis of representation therein shall be reduced to the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. In drafting the amendment, the Congress was looking to make its federal laws, the Enforcement Act, the Freedmen's Bureau Act, and the Civil Rights of 1866 a part of the U.S. Constitution. In doing so, they intended to ensure that the freed blacks would have certain privileges and protections remain in place after the United States pulled its army out of the South and restored the southern states to their previous status as states of the Union. The amendment would also ensure that Congress had the national authority to enforce the provisions of the amendment upon the state that attempted to violate them. Because the congressional acts were merely intended to hold the line until the 14th Amendment was ratified, their intent is significant in determining the intent of the 14th Amendment. Civil Rights Act of 1866. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color shall have the same right in every state and territory of the United States, to the full and equal benefit of all laws and proceedings for the security of persons and property as enjoyed by white citizens. Please note that when the drafters of this bill meant to indicate a citizen, they clearly used the word citizen lowercase, because when defining who the act applies to, the drafters used the word person. As they used both words within the same paragraph, it is obvious that the drafters were keenly aware of the distinction. Clearly, congressional intent was to provide non-citizens with the same fundamental rights as de jure state citizens, who in that day were exclusively white. This intent was further clarified by President Johnson's speech when he vetoed that bill. President Johnson made this statement as part of his speech. Quote, the Civil Rights Bill of 1866, comprehends the Chinese of the Pacific states, Indians subject to taxation, people called gypsies, as well as the entire race designated as blacks, persons of color, Negroes, mulattoes, and persons of African blood. Every individual of those races born in the United States is made a citizen thereof. Once again, it can clearly be seen that the intent of this act was to embrace persons, as defined in Dred Scott's, but in no way was intended to address or alter the relationship of the de jure white citizen to his state of birth or domicile. In the case of the United States versus Utherson, the U.S. Supreme Court found it necessary to review the historical foundations of the Enforcement Act. The court found that Senator Stewart, who had sponsored the Enforcement Act legislation, had made the following remarks regarding the act's intent. Stewart noted that the bill simply extends to foreigners, not citizens, the protections of our laws. He also added that this bill extends the equal protection of laws to aliens, so that all persons who are in the United States shall have the equal protection of our laws. These realities were not lost upon the various courts that were later called upon to make determinations as to the intent of the various civil rights acts of the 14th Amendment. In Van Valdenburg versus Brown, the court made the following statement: no white person born within the limits of the United States and subject to their jurisdiction owes his status of citizenship to the recent amendments to the federal Constitution. As we are now repeatedly drawing the distinction between blacks and whites, this is probably a good point to stop and address the topic of racism as relates to this chapter. This is a historical examination of the law that has existed in the various states of the United States prior to and after the Civil War. Excuse me, and how the foundations laid down in those laws and court decisions may still affect our lives today. This chapter is not intended to critique or pass judgment upon the moral correctness or lack thereof of the laws which existed at that time, or upon the decisions of the U.S. Supreme Court in reference to slavery, Civil War, or the various civil rights acts of the 14th Amendment. It is merely a history lesson with certain inevitable conclusions drawn at the end. Please do not impute any bias in either direction to original intent. As we've examined courts in the latter part of the 19th century, were quite clear on the intended purpose of the Freedmen's Bureau Act, the Enforcement Act, the Civil Rights Act of 1866, and the 14th Amendment. However, what has the Supreme Court said in this century? In Hurd versus Hodge, 1948, the court explained that in order to understand the Civil Rights Act in 1866, quote, a reference must be made to the scope and purpose of the 14th Amendment. For that statute and the amendment were closely related both in inception and its objectives which Congress sought to achieve. The court further stated that the purpose of the 14th Amendment was to incorporate the guarantees of the Civil Rights Act of 1866 in the organic law of the land. Original intent link can also be found in several other cases as well. Justice Harlan noted that privileges and immunities protected by the 14th Amendment included, used in its restrictive sense, those set forth in the first section of the Civil Rights Act. Justice Thurgood Marshall noted that, quote, the Congress that passed the 14th Amendment is the same Congress that passed the 1866 Freedmen's Bureau Act, end quote. He concluded that the rights set forth in the Freedmen's Bureau Act were dispositive of Congress's intent in the 14th Amendment. In 1987, Justice William Brennan traced the rights, actually congressionally granted privileges, that are secured by the 14th Amendment to the Freedmen's Bureau Bill. He then went on to state that the main target of the Civil Rights Act of 1866 were the black codes enacted in the southern states. As can be readily seen, even relatively recent courts have acknowledged that the fact that the 14th Amendment was simply intended to integrate elements of the Civil Rights Act of 1866 and the Freedmen's Bureau Act in the congressional structure of the nation. Accordingly, the 14th Amendment only applies to non-citizens, to aliens, who were the exclusive focus of the Civil Rights Act of 1866 and the Freedmen's Bureau Act. Now that the intent, meaning the proper application of the 14th Amendment, has been illustrated, it is clear that the amendment made federal citizens out of specific aliens who otherwise would have had no form of citizenship at all. By converting these aliens into federal citizens, they fell under the protection of the federal government with regard to those rights that had been conferred upon them by the 14th Amendment. Consideration of these facts, Black's Law Dictionary, 6th edition, defines 14th Amendment this way. 14th Amendment of the Constitution of the United States, ratified in 1868, creates, or at least recognizes for the first time, a citizenship of the United States, as distinct from that of the states. Note the vagueness in the definition. Creates, or at least recognizes for the first time. This vagueness is because Congress's intent purported to embrace only the recently freed slaves. But at the same time, the bare language of the amendment, without consideration of congressional intent, seems to merely recognize the long-standing principle that the federal government has its own citizens, who are not state citizens, a legal reality that existed long before the 14th Amendment. We've covered a lot of ground in this chapter, and it's important to note that with all the evidence that is available, it has never once been asserted by any member of Congress or by the courts that the 14th Amendment or the phrase citizen of the United States, as used before ratification of the 14th Amendment, applies to native-born citizens of a state of the Union. It should also be noted that the original use of the application of the phrase citizen of the United States, lowercase, still continues today, unaffected by the 14th Amendment, which embraced only a few very narrow, specific group of persons. To summarize the points that we have touched on so far, there is an original citizen of the United States of the Union. There is a citizen of the United States, as that phrase has always been used. And there's a citizen of the United States, as the term is used in the 14th Amendment. At this juncture, one might easily rightly ask what was the practical distinctions are in the three forms of citizenship. Before we move forward with that, we should observe that the 14th Amendment merely incorporated into the Constitution the concepts by which the United States had been operating for decades under the doctrine of international law, defining the derivation of citizenship. What made the 14th Amendment necessary was, for the first time, the federal government intended to grant federal citizenship to persons born within a state of the Union. Rights of a citizen of the State of the Union. The Declaration of Independence states that all men are created equal, that they are endowed by their Creator with certain inalienable rights. These clearly lays out the foundation of our rights. We are all equal before God in the law. We possess rights which are inalienable. Those rights are given to us by God, our Creator. Although the men who wrote the Declaration of Independence said that all men are created equal, when it came time to create a legal framework for a government, they understood that they could not include all men in the Constitution, but could only speak for those people who had formed the states, which then resulted in the states creating a national government of limited power. It is the state citizens to whom the phrase all men would have been limited for governmental purposes. Accordingly, as the form of our government began to take shape, the people who would be able to claim these unalienable rights, which the Creator granted, would only be the citizens of the states. While this may seem like a narrow restriction, one must remember that a government can only make laws, including its Constitution, for its own body politic and no one else. So what are these mysterious inalienable rights? The Declaration of Independence says that among these rights are life, liberty, and the pursuit of happiness. While life and liberty and the pursuit of happiness is pretty well all-encompassing, the words of the framers tell us that there are more rights involved, that among them are found the rights of life, liberty, and the pursuit of happiness. In other words, the language of the framers tells us that life, liberty, and the pursuit of happiness is a designated group of rights within a larger body of rights referred to as our inalienable rights. This larger body of inalienable rights is vast. In fact, it is so vast that no one, not even the judicial branch, has ever attempted to list the rights contained therein. This is best illustrated by the old adage that my right to swing my fist ends somewhere before it hits your nose. In short, a citizen can do virtually anything he or she wants, as long as it does not infringe on the rights of another citizen or endanger the community. Also inclusive in these rights are your protections against mistreatment by government, the primary protections being expressly stated in the Bill of Rights in the U.S. Constitution. You have rights antecedent to all earthly governments, rights that cannot be repealed or restrained by human laws, rights derived from the great legislator of the universe, John Adams. The U.S. Supreme Court has stated that because these rights existed antecedent prior to the formation of either the states or the national government, they are outside the government's power to alter, modify, or abolish. How's that for some strong protection? With these powerful rights in our hands, one might wonder what sort of rights are possessed by citizens of the United States. Poor stepchild citizen. If the citizens of the United States of the Union have their inalienable rights, what then do citizens of the United States have? Frankly, nothing much of value. For the balance of this section, we will use the term federal citizen to denote a citizen of the United States. A federal citizen has only those rights which have been granted to him by Congress by way of the numerous and various civil rights acts, and such rights as may have been vested in him by an activist U.S. Supreme Court that felt it could legislate from the bench. Let's be clear, God does not give the rights to federal citizens to them as our inalienable rights. Congress gives them their rights to them alone. And the most significant point to understand and keep in mind is that what Congress gives, Congress can take away. It has always been this way, and it will always be this way. The only thing that may be surprising in all this is it's the first time you're hearing it. Most Americans have no idea that there are two classes of citizenship, nor do they understand the vast distinction between the two and what it means in their lives. Let's look at what the courts have said about federal citizenship. A civil right is considered a right given and protected by law. Any person's enjoyment thereof is regulated entirely by the law that creates it. The persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words is not merely subject to some respect or degree to the jurisdiction of the United States, but completely subject. Well, in Elk versus Wilkins, is a 14th Amendment case, the concept is still true concerning all federal citizens. In other words, all federal citizens must be, by their very definition, a person who is completely subject to the jurisdiction of the federal government, such as a citizen of the Washington, D.C. Virtually any legal concept stated by the courts concerning the 14th Amendment citizen is operative upon all federal citizens. The Privileges and Immunities Clause of the 14th Amendment protects very few rights because it neither incorporates the Bill of Rights nor protects all rights of individual citizens. Instead, this provision protects only those rights peculiar to being a citizen of the federal government. It does not protect those rights which relate to state citizenship. That's Jones versus Timner. The first 8 amendments have uniformly been held not to be protected from state action by the Privilege and Immunities Clause of the 14th Amendment, Hague versus CIO. The right to trial by jury in cases guaranteed by the 7th Amendment and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileges and immunities of citizens of the United States guaranteed by the 14th Amendment. And in effect, the same decision was made in respect to the guarantee against prosecution except by indictment of a grand jury contained in the 5th Amendment, in respect to the right to be confronted with witnesses contained in the 6th Amendment. It was held that the indictment made indispensable by the 5th Amendment and trial by jury guaranteed by the 6th Amendment were not privileges and immunities of citizens of the United States as those words were used in the 14th Amendment. We conclude, therefore, that the exemption from compulsory self-incrimination is not a privilege or immunity of national citizenship guaranteed by this clause in the 14th Amendment. Twining versus New Jersey. There are then under our Republican form of government 2 classes of citizens, one of the United States and one of the states. Gardenia versus Board of Registers, Jefferson County. The governments of the United States and of each state of these several states are distinct from the others. The right of a citizen under one may be quite different from those he has under the other. Colgate versus Harvey. Rights of national citizenship as distinct from the fundamental or natural rights inherent in state citizenship. Madden versus Kentucky. There is a difference between privileges and immunities belonging to the citizens of the United States as such, and those belonging to the citizens of each state as such. Ruchette versus People. We have in our political system of government of the United States and the government of each of the several states. Each one of these governments is distinct from the others, and each has citizens of its own. United States versus Cruikshank. It's quite clear, then, that there is a citizenship of the United States and a citizenship of the state, which are distinct from each other and which depend upon different characteristics of circumstances in the individual. Slaughterhouse cases. It should be noted that many of the rights not attributed to federal citizens in the cases above have since been granted to them by Congress or by the courts. These early decisions simply clarify and solidify the reality that federal citizens are not the same class of citizen as a state citizen. Like so many areas in which the federal government has tread, it is an unbalanced equation, where at one time there was no real problem with there being 2 different classes of citizens. With the ratification of the 14th Amendment, Congress went into overdrive with civil rights legislation. The result was a labyrinth of rights and protections of federal citizens. Some of these laws have even found their way into additional constitutional amendments. Because a state citizen is a member of the people to whom the sovereignty of the states, and by association the national government resides, such a citizen is left to protect his own rights, with no special process to help him accomplish that end. In short, he must defend his rights with all of his will, his energy, and his money, and passion in the courts as long as it takes to reach a final outcome. Conversely, a federal citizen need only lodge a complaint with the appropriate federal agency, and the power of the federal government moves to punish the person who has allegedly violated that federal citizen's rights. Of course, this is legally appropriate since a federal citizen is little more than a ward of the national government. The government must care for such second-class citizens as they are not the masters of their government but mere servants to it, and the master's responsibility is to care for his servants. Now, we'll stop there and comment a little bit. Since I know this stuff, and so I understand that I have absolutely no business in federal court. They have no jurisdiction over me, and I have no business going there for any reason. But let's take this off the record here. And when I graduated law school, I went to I graduated engineering school. And I went work right away for Boeing Aircraft as an engineer. They recruited me on campus. I went up there in Seattle. I was engineer for Boeing. So I graduated law school. I said, why would I want to pay them my interest in my trust account and a yearly dues and have them tell me what I can and can't do?
Who's they?
The bar.
Okay.
Why can't I advertise? So I said, hell with it. So like an engineer, I went and practiced engineering without joining a professional engineer association. So in Florida, I opened up my law office, Mel Stamper Law, and I started practicing in every court. 10 years, I practiced in state and federal courts. And one day, I just kicked the shit out of my opposing counsel. And on the way out of the courthouse, he says, Mel, I don't see you at the county bar meeting. I said, I'm not a member. Well, of course you are. If you remember the state bar, you remember the county bar. I said, I'm not a member of the state bar either. What? You're practicing law without a license? I said, no, I'm not practicing. I know what the fuck I'm doing. So at that point, he didn't like that answer. And he went back, and about 2 weeks later, a little girl came in my office, really foxy young girl. Really, Even an old man like me, you'd notice. And she wanted to get a divorce, wouldn't talk to anybody except me. I had 2 lawyers working for me, a couple paralegals, but she only talked to me. That's all she wanted to talk to. So it was set up. But I was a cop in Chicago for 9 years. I smelled another cop a mile away. So I knew she was a cop. I thought she was federal, but she was state. So she asked me about a divorce and all these questions. Well, she's a different county and didn't want it publicity, so she wanted to do it in another county. Can't you do that? And all these different questions. And I said, okay, where's your husband's bank account located? I'm not sure. I don't know. How much money does he have? I don't know. But not a woman to lie, but doesn't know where every penny of her husband's money's at. That's the first lie I knew. And so when she left, I told my paralegal to check the county records to see if there's any record of her existence. There was no voting record. There was nothing on record of her even existing. So I knew she was either state or federal. So I forgot about it. I sent her a deposit back until I couldn't handle her case. Anyway, I got a call from the state's attorney, who I used to play golf with every Wednesday. He called me and says, Mel, I got information here. We're going to file against you for practicing law without a license. And I said, oh, fine. He said, do you want to talk about it? I said, no. See you in court. So, go to court. Anyway, I went to his office to pick up the document, and I saw the little girl there and her boss, and a couple people from the bar, investigators, and they all said, well, you want to discuss this? No, we'll see you in court. So a year goes by, and they tried to arraign me, and I had all kind of motions to dismiss, and after 1 year, the judge got fed up. She says, what the hell's going on here? This is not a murder case. This is a misdemeanor case. What's going on? He said, well, Your Honor, we'll not only process if he promises not to break the law. I said, I'll stipulate to that. I've never broken the law. Of course I'll stipulate to that. They dismissed the case. I've been preparing my lawsuit against them for over a year. And so as soon as they dismissed it, I went and filed in the federal court and sued them under the Fourth Amendment violations, 2 counts. Because in Florida, to investigate with a wire, which is what they had all the evidence, the tape recordings, there must be a felony investigation with a warrant issued by a court. It was a misdemeanor investigation, and there was no warrant issued. So they tape recorded my conversations illegally. And so I charged them. I started for $3.5 million. I sued everybody in the world. I let God sort them out as far as plaintiffs. And I sued them in federal court under the 14th Amendment. And now I know the 14th Amendment's not for me. But when it's to my advantage, I'll use it. And if it's not to my advantage, I don't use it. If they're charging me with something, I'm not in the 14th Amendment. I challenge jurisdiction. But if I want to use it, yeah, I'm one of them. Here I is, master. So as long as you know the difference, you can use those things yourself if you know the difference, how to use them. Anyway, the result of that is that they moved for dismissal, and the judge did not grant it. They want to go to trial. And on the day of the courthouse, when we were going to voir dire the jury, they said, no, we'd like to make a settlement offer with you. Well, I said, well, what do you want to offer? They said, we'll offer you this much. I said, no, I'll get more than that in punitive damages. Well, how much you want? So I gave them a number. I would accept. And 2 weeks later, they called me. We'll go buy it. But we won't admit any wrongdoing, and you can't tell how much you got.